All right, thank you, Lynn. Let's start over again. Welcome to the Arizona State Board of Pharmacy meeting. It's February 15th, 2024, and I'll call the meeting to order. Before we get started with roll call, I do want to just remind the public of our mission. The Arizona State Board of Pharmacy protects the health, safety, and welfare of the citizens of Arizona by regulating the practice of pharmacy and the manufacturing, distribution, sale, and storage of prescription medications and devices and non-prescription medications. One housekeeping note. As if you were in attendance yesterday or listened online, we are now offering Arizona CE for the board meetings again. So if you are interested in CE and you are an Arizona pharmacist or technician, make sure that you sign in at the door so that you can get your CE certificate. It's 1.5 hours for the morning session, 1.5 hours for the afternoon session. You'll have to sign in for both sessions if you want to get credit for both of the CEs. So make sure that you take the opportunity to do that. And now we'll turn it over to Dr. Gandhi for roll call.
Thank you, Madam Chair. Mr. Thorwald.
Here.
Ms. Nair.
Here.
Ms. Davis.
Present.
Ms. Walmsley.
Here.
Ms. Lehan.
Present.
Mr. Dang.
Here.
Mr. Al-Nassif.
Here.
Mr. Anderson.
Here.
All accounted for, Madam Chair.
Thank you, Dr. Gandhi. Any additional conflicts of interest from anybody as of yesterday, or nothing additional? Okay. We will jump into tab 27, which is cases recommended for the approval of state's motions to vacate the hearing. This is the time for the board to consider consent agenda items 27A through 27D. Desiree Barnes, board case number 23-0014. Kevin Alonzo Tselaki, board case number 23-0396. Christopher Worthley, board case number 23-0603. Christina Montiel, board case number 23-0233. Does any respondent or attorney or member of the board want to pull these cases from the consent agenda for further discussion? I do want to pull case 27 A, because I am recused from that. But I also see that it's not on the agenda, so I might need some direction from staff. It's not on the printed agenda that I have.
One more time, is what's not on the printed agenda.
So 27A is still set to be heard.
It's set for a motion to deem the
Okay.
allegations as well as to vacate the hearing.
Okay. I am recused from that one, so I'll take direction. Do you want me to step aside for that? Do you want to take the other three together?
That's completely up to you if you want to take the other three together, unless anyone else has something they want pulled.
Is there anything else anybody wants pulled? Mr. Hargraves?
I don't need anything pulled.
Okay. So let's do the other items together, 27B, C, and D, and then I'll let Ms. Davis do the others. Does any respondent or will the state's attorneys please introduce themselves?
Yes, good morning. Seth Hargraves, Assistant Attorney General on behalf of the state.
Are there any other parties present for these matters?
I don't believe so.
The state has filed a motion to deem and to vacate the hearing in each of these matters. If these motions are granted, the board will have adopted the factual allegations set forth in the complaints as its findings of fact and the alleged violations of law as conclusions of law. Is there a motion with regards to the state's motions to deem?
I'll make a motion to accept the motion to deem and vacate the hearing in each of these matters.
Second.
I have a motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, we will now deliberate on the appropriate discipline to be imposed. Any discussion?
I move to adopt the state's recommended discipline as set forth in its motions to deem and vacate the scheduled hearings.
Second.
I have a motion and a second. Any further discussion? Dr. Gandhi, if you want to do roll call, please.
Certainly, Madam Chair.
Aye.
Mr. Thorwald.
Aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lehan,
Aye.
Mr. Dang, Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Ms. Davis, I'll let you repeat for item 27A.
This is the time for the board to consider consent agenda item 27A, Desiree Shree Barnes, board case number 23-0014. Will the state's attorneys please introduce themselves?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Are there any other parties present for these matters?
I don't believe so.
The state has filed a motion to deem and vacate the hearing in this matter. If this motion is granted, the board will have adopted the factual allegations set forth in the complaints as findings of fact and the alleged violations of law as conclusions of fact. Is there a motion regarding the state's motion to deem?
I move we accept a motion, state's motion to deem and vacate the hearing.
I have a motion. Do I have a second?
I second.
Thank you. Any other discussion? Okay, all those in favor? Aye. Any opposed? Perfect. Now, we'll now deliberate on the appropriate discipline to be imposed. Do I have a motion?
I'll make a motion to adopt the state's recommended discipline as set forth in its motion to deem and vacate the scheduled hearing.
Second.
I have a motion and a second. Any other discussion? May I have a roll call, please?
Certainly, Madam Chair. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis.
Aye.
Swamsley's recused. Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you. This concludes these proceedings. The board's decisions will be reduced to written orders, which will be sent to each of the respondents. Thank you.
Thank you, Ms. Davis. Let's go to 28A. This is the time and this is the date, time, and place where the matter dealing with Twadros Mihari board case number 23-0530 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Tennille Davis, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Jeff Anderson, and Tariq Al-Nassif. Let the records reflect that the board members have been furnished copies of the complaint and notice of hearing and all pleadings of records. Will the parties please introduce yourself, starting with the state?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Is Mr. Mihari present?
Don't believe so.
Right. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Mr. Hargraves, would you like to make an opening statement?
Yes, thank you. Just briefly, this case deals with a issue of non-compliance with a board order by Mr. Mihari, a licensed pharmacy technician trainee. In January of last year, this board issued Mr. Mihari a non-disciplinary civil penalty in the amount of $250 to resolve case number 22-0681. In April of last year, this board denied Mr. Mihari's request to reconsider that penalty, and you granted him an extension to pay. Despite that extension, he did not pay. The board voted to hearing, and here we are. Thank you.
Thank you, Mr. Hargraves. Do you have any witnesses you'd like to call?
Yes, Jennifer Kiangavong.
We need to swear Ms. Canavong in. Ms. Canavong, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Could you please state your name for the record?
Jennifer Gilnavong,
And what is your current position with the board?
a Deputy Director.
Are you familiar with a case involving Twadros Mihari?
Yes.
And could you tell us what that case is about, this hearing's about today?
Yes, this is a case of
that respondent failing to comply with the board order.
And is Mr. Mahari licensed with this board?
Yes,
In what capacity?
as a pharmacy technician trainee.
You can take a look at what has been marked as States Exhibit 1, Bates page, I believe 5343. Could you identify this document?
It's the primary source verification.
And what does this indicate?
This is Mr. Mahari's verification of his license.
And what is the status of that license?
Open.
Now, this case deals with noncompliance with the board order, you said?
Correct.
Okay, if you can go to what's marked as States Exhibit 2, beginning on Bates page 4, Board Book page 5345. You can tell us what this is?
Yes, this is a letter from board staff indicating that there is an enclosed order for a non-disciplinary civil penalty order,
And what's the date of this letter?
January 25th, 2023.
And what case is this referencing?
22-0681.
And looking at the next page, page 5, what is the order and what's it for?
This is an order for non-disciplinary civil penalty for failing to provide notice of a new criminal charge, arrest, or conviction in any jurisdiction.
And was there a time frame for which this needed to be paid?
Yes,
And what was that time frame?
within 90 days from the date of issuance of the order.
Moving to what's marked as States Exhibit 3, Bates page 8, Board Book page 5349. What is this?
This is a meeting notice that was sent to Mr. Mahari for consideration of his appeal of the order for non-disciplinary civil penalty,
And what's the date of this letter?
March 2nd, 2023.
And when was this going to be reviewed by the board?
This was set for review on April 6th, 2023.
And looking at the next page, page 9, what is this?
This is Mr. Mahari's appeal of his non-disciplinary order.
And did the board consider that at their April meeting?
Yes,
Looking at what's marked as States Exhibit 4, Bates page 11, Board Book page 5352. What is this?
this is a letter to Mr. Mahari informing him that the board considered his appeal. And after review and discussion, the board decided to uphold the order, but extend the deadline for payment,
Okay, and what's the date of the letter?
April 7th, 2023.
With the extension, did Mr. Mahari pay the penalty?
He did not.
And looking at what's marked as States Exhibit 5, Bates page 14, Board Book page 5355. What is this?
This is a communication to Mr. Hari notifying him that the board opened a complaint against his license after he failed to comply with a board order,
And what's the date of the letter?
September 19th, 2023,
And what is the new complaint number?
23-0530.
Did he respond to that letter?
Yes, he did.
He did respond?
No, he did not. I apologize.
Look now at what's marked as States Exhibit 6, Bates page 20, Board Book page 5361. What do we have here?
Can you repeat the page, please?
Bates page 20.
This is a communication to Mr. Mahari that his case was being, that the board would consider forwarding his complaint to formal administrative hearing due to failing to respond to the subpoena,
And what is the date of the letter?
October 27th, 2023.
And this indicates the board's going to review that at their December meeting.
Correct.
And what happened at the December meeting?
The board referred the case to hearing.
And looking at what's marked as States Exhibit 7, Bates page 22. Is this the complaint notice of hearing in this matter?
Correct.
And did Mr. Mahari respond to this?
Yes, he did.
And looking at what's marked as States Exhibit 8, Bates page 30. Is this his response?
Yes.
And what was his response?
He responded that he was reaching out to surrender his license.
Was he given an opportunity to do so?
Yes,
Was he sent a consent for a surrender to consider?
yes,
Did he sign and return that?
no,
Has he paid the non-disciplinary civil penalty?
no.
Thank you. No further questions. And no further witnesses.
Thank you, Mr. Hargraves. Does the state wish to rest their case?
Yes,
Would you like to make a closing argument?
yes, thank you. The evidence and testimony has demonstrated the allegations and violations set forth in the complaint notice of hearing that Mr. Mahari has violated a board order. The state asks that the board adopt the factual allegations and alleged violations as findings of facts, conclusions of law, and enter disciplinary action against Mr. Mahari's license. Given the fact that he has failed to comply with the board order and has indicated at least that he no longer wants his license, the state would recommend revocation. Thank you.
Thank you, Mr. Hargraves. Board members, any discussion or thoughts on motions?
Well, I'll make a motion to adopt the factual allegations and the alleged violations from
Oh,
the complaint.
I
Yeah.
apologize. I would move to admit exhibits 1 through 8 into evidence.
Do I have a motion?
I'll make a motion to admit those into evidence.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none? Go ahead with your motion on the allegations.
Now I'll make a motion to adopt the factual allegations and allegations of unprofessional conduct from the complaint and notice of hearings as findings of fact and conclusions of law.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none. Mr. Hargraves has made a recommendation of revocation as the matter of discipline. Is there any discussion or a motion?
Make a motion to accept accept the motion of revocation. I don't know how to state it.
Would you like?
Yes,
Okay,
please.
thank you. For the record, Diane Didia, Assistant Attorney General, serving as the board's independent legal advisor. Sorry. So the motion would be to accept the state's recommendation of revocation of the license. And then we would need a roll call vote.
Okay, I accept the state's recommendation of revocation of the license.
Second.
I have a motion and a second. Any discussion? Dr. Gandhi?
Mr. Thorwald,
Aye.
Ms. Nair, Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. This concludes this matter. The board's decision will be reduced to a written order. Thank you for attending. Next up on our agenda is item 30A. Informal settlement conference on case number 24F 23-0357. Got a couple people approaching.
And Madam Chair, Marcuse.
Okay, thank you. Good morning, Mr. Rain. If you could please introduce yourself for the record.
Hi, Michael Rain with the law firm Bozen and Snow on behalf of Mike Jada.
Mr. Jada, if you could please introduce yourself as well. Push the mic. You can remain seated.
My name is Michael Jada, pharmacist.
Thank you. And the state, if you could please introduce yourselves as well.
Seth Hargraves, Assistant Attorney General on behalf of the state.
Jean Galvin, Assistant Attorney General on behalf of the state.
Since this is an informal settlement conference, I believe we go to you first, Mr. Rain, if you'd like to present your client's request.
Sure, and thank you, Madam President and members of the board for your time today. Often with these settlement conferences, there's some preliminary discussion to make sure we understand the context is a settlement conference. The discussions that we have in settlement conferences are confidential. in theory, in a room full of people. That seems weird to say, but what that means is that what's said today can't be used in a hearing repeated. Of course, you know, it can be investigated, it can be talked about, but in a hearing, no one could come and say, well, Mr. Jada said this, because he would have said it during this confidential settlement conference. Also, just as a point of clarification, we didn't request a confidential settlement conference. What we requested was an appearance before the board, because what you might remember is back in October, I believe it was October, we had our meeting to discuss this matter where the board imposed a summary suspension. And at that time, what we had presented to the board is the same thing we'll present to you today, which is a request that Mr. Jada be allowed to participate in a PAPA program under a probationary order, generally with the same terms that you offer most licensees, or with the terms that you feel comfortable with. And we can talk about those if you're interested in diving into it, what might make you feel comfortable regarding, you know, your mission to protect the public. But at that time, what Mr. Jada's plan was to go get an evaluation. Hadn't been ordered by the board, but he went and got one, but it wasn't in place. And I recall the board saying essentially, hey, he can go do that. Let him go do that. We're going to move forward today with the suspension, and he can present that, you know, to an ALJ, and it'll come back to us, and we'll consider it when it's in place, but it's not in place yet. Well, he went and got that evaluation, and we notified board staff about that. And eventually there was some confusion. Board staff didn't get a copy of it. We made sure they got a copy of it, and we asked to be on the agenda to present it to you. Now, the hearing in this matter is not scheduled for a few more months. Mr. Jada has waived the timing requirements. As you may recall, when you summarily suspend people, you're supposed to go straight to hearing because they've been suspended without a hearing. So it's for the licensee's benefit. But Mr. Jada has said, I'm not in a rush. I understand the concerns. And so he's waived that, but the state has now gone back to court and said, we want to go to hearing. We want to go quickly. And so that's where we are. I don't think there's a genuine time crunch because he is suspended. He cannot practice. He has waived his timing rights for the hearing. So while I understand the desire to proceed quickly through any matter, that isn't always the case with board matters. We have matters you voted to hearing that have been pending for almost a year before a hearing happens. Where there isn't a suspension in place that's going to, you know, protect the public. And so with that background, I guess what I plan to do for the rest of our presentation is Mr. Jada does have a written remarks that he would like to read to you. I don't anticipate there being a question and answer session. This is not a hearing where Mr. Jada plans to testify. Wouldn't really matter anyway, because none of it can be used later. But, you know, I can answer questions that you may have. As you may know, the allegations you have in a complaint against Mr. Jada are very serious. Your file includes reports to law enforcement about his conduct that is alleged. And so he also has to consider those issues, you know, whether it's here or in a hearing, that he has to consider his liberty as another interest that he has to think about. And as you may know, you can refuse to testify in a civil matter and have that used against you, unlike in a criminal matter. It can be, you can take a negative inference if someone doesn't testify in a board hearing versus, you know, in criminal law, you have the right to remain silent. And so we don't really anticipate, as long as there's this other thing hanging over Mr. Jada's head, that he's going to participate with the testimony that he might need to defend himself. And so our anticipation is, one way or another, the facts that are in your complaint and the legal, the allegations of unprofessional conduct will ultimately wind up in an order as findings. That's where it's headed. And so today, what we offer is, let's do it. Let's do it now. Let's put it in a consent agreement, a PAPA consent agreement. Mr. Jada has an evaluation. That evaluation does say that he is a candidate for the PAPA program. And you may recall, I took a lot of issue back when we spoke about this case months ago, that the state's attorneys were saying that he didn't have an issue. He doesn't qualify because of this reason or that. And I said, well, like me, we're just attorneys. We're not healthcare providers at all, but we're certainly not psychiatrists qualified to make that decision. And I think as time has passed, I've been proven a little right there, because when a psychiatrist was asked to do this, the psychiatrist that presents all the orders, many of the evaluations that you review, Dr. Faria, when she had the opportunity to speak with Mr. Jada, in her professional opinion, there was an underlying concern. There was a qualification, for lack of a better word, for Papa and an ability to rehabilitate. And those are the things you look at in an evaluation, and you generally don't second guess an evaluation. I think that psychiatrist doesn't know what he or she is doing. You send these to those professionals because they're the ones who have the quality education, the type of education, I should say, to make that determination. And so with that, the offer would be essentially that, to consider a PAPA agreement. Now, you have flexibility. They're very similar from case to case, but you do change things from time to time. Normally, you'll have a 6-month suspension period to begin, but you could make that shorter. You can make that longer in any given case. But what we also know is then licensees come to you and say, can I go back to practice? And it's completely up to your discretion. If you want them to remain suspended for whatever period of time you think is adequate, either to punish conduct that has been acknowledged in an order, to rehabilitate, to deter, any reasons you want, you can set a suspension period at what you think is appropriate. I mean, I don't think it's kind of 6 of one, half a dozen of the other, because if it's 6 months, as the normal agreements are, but he comes back in 6 months and says, I'm ready, and you absolutely do not think he is, well, then you say so, and he remains suspended. And in that process, all the while, he's participating in the PAPA program. He's getting treatment. He's getting the help that Dr. Faria suggests he needs. And so you have this very, very valuable secondary benefit. The whole point of the program is that benefit, candidly. I mean, that's the point, to help licensees who are found to need it. And if he ever violates the contract, as you know, it's automatic suspension. We fought that with you before. People should have a hearing, and right, and no, it's automatic suspension. And so you're completely protected there in terms of any missed testing, any missed appointments, any failure to update the board with any details. So, all the while, Mr. Jada remains suspended until your board says he's ready. And that day may never come. It would be up to you. And so with that, you would absolutely protect the public. You have all the power. You get the order that you're seeking in a hearing, which will be a multi-day hearing, a very big expenditure of time. And really, it's being offered to you essentially right now, to just have an order signed, and everything's proven and everything's admitted, at least in the context of a consent agreement. And so with that, I've spoken enough. I do want to give Mr. Jada the opportunity. He has about a page of prepared statements. I will allow him to present that.
Thank you, Mr. Ray. Mr.
you.
Jada, go ahead.
I'm going to stand. Is that okay?
However you're comfortable.
Good morning, esteemed board members. Thank you for allowing me the opportunity to meet with you today. My name is Michael Jada, and I'm here today with the utmost sincerity and humility to address the findings and discipline concerning my pharmacist license. I willingly accept accountability for my actions, and I'm fully committed to rectifying the situation. I have devoted 14 years of my life to the pharmacy field, practicing as a pharmacist for 7 of those years. Since high school, I embarked on a journey to discover a career aligned with my true calling in life, a career that allows me to genuinely care for people's health and happiness. The moment I started working as a pharmacy technician at 18, I knew that I had found my calling in the medical field. Becoming a pharmacist, however, was not an easy feat. My journey included facing the disappointment of not being accepted into pharmacy school on my first attempt. Despite this setback, I persevered, worked diligently to support myself while maintaining competitive grades. The following year, I reapplied and successfully gained admission. My faith in myself never wavered, and I graduated with the determination to make a positive impact on people's lives. My initial role as a new pharmacist in the retail setting allowed me to connect with the community I served, particularly in Sun City, a retirement community with mostly elderly patients. Over time, I earned their trust and felt the profound impact of my role. I became more than a dispenser of medications. I became a source of support during difficult times, a key figure in their healthcare journey. However, I must acknowledge that I lost sight of myself along the way. The challenges of pharmacy school took a toll on my personal life. I distanced myself from my friends, family, and even neglected my own health. Excuse me. I struggled with stress and regrettably turned to drinking as a coping mechanism. This not only affected my well-being, but also took a toll on my relationships and career. In August of 2023, I made the difficult decision to resign from my position as a pharmacist. Since then, I have not been working, but I took the proactive step towards recovery by enrolling in PAPA. This program has been instrumental in providing me the necessary support and courage to embark on my journey to recovery. I'm deeply grateful for programs like PAPA, facilitated by the Arizona Board of Pharmacy, which have been instrumental in my most challenging times. Dr. Monica Faria, the medical director of PAPA, has evaluated my progress, and I urge you to consider her findings and allow me, under tight supervision, the opportunity and privilege to continue my path in recovery. I recognize the gravity of the responsibility that comes with holding a pharmacist license, and I assure you that I'm fully committed to upholding the highest standards of care and professionalism. Allow me to share with you a few examples of moments that illustrate the essence of why I became a pharmacist and why I'm so passionate about this profession. There was a time when I intervened on behalf of a child whose blood thinner dose was double what it should have been. Through my vigilance and expertise, I prevented a potentially life-threatening situation and ensured that safety of that child. Similarly, there was another instance when I intervened on behalf of an elderly patient who needed a life-saving medication, and I worked diligently to obtain that medication for her that day, preventing unnecessary risk and potentially saved a life. These moments are merely two examples of the endless interventions I have made as a pharmacist, though small in the grand scheme of things. Embody the essence of my dedication to patient care. They represent my unwavering commitment to making a positive impact on the lives of those who entrust their health to me. While my experience has solely been in retail, I can assure you that regardless of the capacity in which I work as a pharmacist, my commitment will never waver. I stand before you today, not as someone who is perfect or infallible, but as someone who is willing to learn from their mistakes, to grow, and to become a better pharmacist because of them. I understand the importance of supervision and accountability, and I am fully committed to embracing these measures to ensure the safety and well-being of our patients. please, please, do not let this moment define my pharmacy career. Instead, allow it to be a catalyst for growth, for reflection, and for a renewed dedication to the principles that guide us as pharmacists. Lastly, I humbly ask your blessing, your guidance, and your support as I continue on this path of recovery, redemption, and service to others. With your help, I'm confident that I can once again become the pharmacist that I aspire to be. One who makes a positive difference in the lives of those we serve. Thank you very much for your consideration.
Thank you, Mr. Jada. Mr. Rain, anything else to add? All right, Mr. Hargraves, Ms. Galvin, I'll let you take it over from here.
Thank you. In October 10th, 2023, this board considered whether to summarily suspend Mr. Jada's license pending an administrative hearing. At that time, Mr. Rain approached you and asked you to consider allowing him to enter into a PAPA contract. At that time, there had been no evaluation. At that point, Mr. Jada was still maintaining that he had done absolutely nothing wrong. There was question on behalf of the state that there's been no showing of any need for a PAPA evaluation. He was still maintaining he had done nothing wrong. Nothing had been addressed to this board of what those issues may be. And in fact, Mr. Rain himself told this board, well, that's going to be up to the evaluator to determine what his issues are. The board felt that you didn't need an evaluation to go forward. And you told him, if he wants to get an evaluation or bring it to the hearing, so be it. The board summarily suspended, the hearing was set. Now, they were able to get a continuance in one part of the initial hearing date, one part because of the extreme volume of material here, and so that they could get the evaluation. As soon as the evaluation was obtained, we had a scheduled status update with the administrative law judge. The state filed a response saying they got their evaluation, let's set the hearing and move forward. With the evaluation, Mr. Rain asked for the opportunity to come before you to consider a different outcome, basically a settlement allowing him to go into a PAPA contract. Although he didn't request specifically a settlement conference, that's essentially what he did request. He wanted an opportunity to come before you to consider a settlement option to a case that had been set and scheduled for hearing. Now, the grounds that they're giving to allow this, asking this board to allow him to go and resolve this with a PAPA contract is the evaluation from Dr. Faria. Mr. Jada is encouraging you to consider those findings. Well, please do consider those findings. Because if you look at it, the issues that are the basis for her recommendation are his conduct, his issues that began in 2019. However, the issues that began in 2019 or that were the result of his issues in 2019 had been going on for 3 years before that. They started in September of 2016, 1 month after he obtained his pharmacy license. The exact same conduct continued on, and they're claiming that, well, his issues that why you should resolve this with a PAPA contract, they began in 2019. They didn't begin in 2019. And, if you look at Dr. Faria's report, she conditions it that the accuracy is influenced by factors, basically the veracity of Mr. Jada. And the report goes through different issues that were the factors that she considered, and the state in its memo had pointed out that possible inconsistencies with those positions. The fact of the matter is that this case deals with the fact that since September of 2016, Mr. Jada has processed false prescriptions for opioids. He has, for a long period of time, processed written scripts for opioids that should only have been processed electronically, submitted electronically. He was processing them anyway. You know, you've heard from the DEA about those issues and concerns. The board is aware of the opioid problem in this country. This isn't something that started in 2019. This has been going on and on and on. Now, he says he accepts accountability, but has he? I haven't heard anything acknowledging what he's done. The file in this matter is extensive. And what it shows is that there are over 77 opioid oxycodone pills that were sent out into the public for people without a valid prescription, and we don't know where they went, where they ended up. That is a threat to the public.
Mr. Hargreaves, one question. Was it 77 or 77,000?
It was over 77,000.
Okay.
Thank you.
Just,
You know, there is nothing that prevents Mr. Jada from entering a PAPA program, getting help for his issues. It doesn't mean this board has to accept that as a resolution of this matter and allow him to keep his license. Again, the issues weren't causing this conduct was going on long before his stated issues. PAPA is not going to fix that. You know, it may fix whatever issues he has. It's not going to address the issues that are before you in this case. The state would recommend that the board reject any settlement that includes entering the PAPA, keeping his license, and pretending like none of this happened. Thank you.
thank you, Mr. Hargreaves. Mr. Rain?
Yes, thank you, Madam Chair. You know, I heard from the state exactly what I told you that you would hear, that Attorney General Hargreaves is telling you what to think of a licensed psychiatrist's opinion. And he just has no foundation for that. There's no reason for you to listen to that and give it any credit. He is not a psychiatrist. No other psychiatrist has given you any opinion, and no other psychiatrist gives you other opinions in other PAPA cases. And I can guarantee you, go look at Dr. Faria's reports. They always say that her information is based on information gleaned from the person she speaks with. That is not unique to Mr. Jada. PAPA is always available for everyone. That is always true. That's not unique to Mr. Jada. Yes, he can and will go get treatment, no matter what you do. And that is true of everyone who comes before you that you put into a PAPA contract. It is also quite true, very often quite true, that people who enter these contracts have engaged in admitted acts that are quite serious and merit revocation. And there is no dispute that the allegations that the board has raised merit revocation. We are not disputing that. Those are serious allegations. And Mr. Jada will necessarily acknowledge them formally in an order. So that is also not true. He will. He's here today. He just can't simply speak openly because of the seriousness of the allegations in an informal settlement conference environment where he has nothing to gain by it. When the writing's on the wall, that is exactly what happened. When you enter a PAPA contract, you acknowledged the findings. And so I would ask you, you know, if you don't like Dr. Faria's report for one reason or another, there's a remedy for that. Let's get a supplemental report. Let's get someone to have a licensed person competent to talk about these things come talk to you about them. But neither me nor any other attorney in this room should be up here telling you their opinion about a licensed psychiatrist's professional opinion. There's a reason we need expert witnesses in cases and we can't just talk. By the way, it's also not accurate that when we came back here in the summer suspension meeting that Mr. Jada was not willing to accept responsibility. That's exactly what we were doing. What actually happened was during a board meeting, well before you ever had this case in front of you, staff pulled me aside and said, can we come talk to you? We went into the room right there and they pulled out a computer and they said, look at this evidence we have against Mr. Jada. And I said, and they offered me an interim suspension. And I said, well, the interim suspension is worse than a summary suspension. So I don't know that we'll take it because my client's recently hired and has not acknowledged responsibility. I don't think he's going to accept it. And I don't think I would advise him to accept it. That's the whole factual basis for what Mr. Hargreaves is talking to you about. Not Mr. Jada saying anything, not a hearing happening, an impromptu surprise meeting on the side where I was shown for about 30 seconds some images on a screen and asked to have my client admit or accept discipline that's worse than the discipline you could possibly impose if he did nothing. That's the actual factual record that we have basing all the state's position. And so I would just ask you to realize this isn't different than all your other cases. It's someone who's engaged in alleged misconduct that merits serious discipline, who's gone to a licensed psychiatrist who's opined that he had an underlying mental health condition that motivated and impacted his decisions, and that he can be rehabilitated, but that he's only safe to practice under certain tight conditions. And you can engineer those conditions however you see fit, but the result will be you'll have all your findings that you're going to seek in that hearing admitted, and you'll have all the power to never let Mr. Jada practice again if that's how you feel. And I can assure you, he's not going to come back to you in 5 months and say, all's well. We know the seriousness of these allegations. But if he comes back to you in a year and you're still not comfortable, you say no. So with that, thank you.
All right, I'll entertain board discussion.
Madam Chair, I have a question for Mr. Chada. So Mr. Chada, you had shared with the board earlier about the 2 patients that you had saved, helped saving their lives. When did these 2 life-saving scenarios occurred during your career as a pharmacist?
He doesn't have the dates of these events.
But it occurred during the time when you were practicing as pharmacist,
Yes.
correct? Okay. So my follow-up question is, well, these acts are very noble, in my opinion. Why didn't you use these noble, caring act as the catalyst for your professional growth? But instead, since graduation up until 2023, you have been continuously dispensing narcotics that add up to be more than 77,000 tablets of oxycodone to the public. So the information that's sharing to us is conflicting or contradictory to me. On one side, you're telling the board that you're valuing your career as a pharmacist. You're utilizing your career to help people, to save people. But on the other hand, you're abusing your career, using your title as a pharmacist and dispensing fraudulent prescription to the public. So to me, that's contradiction.
Is that a question or statement?
So I'm asking, but he didn't share any additional information from the questions that I have. So that's a statement.
I have a question. So in summary, our options today are to resolve with a PAPA contract or to proceed to hearing, correct?
Ms. Dadia?
Yes, so the board's options are today to either one, accept the respondent's settlement offer, which is a PAPA contract, and then you can, put in whatever terms that you would like that to be. You can reject it flat out, or you can offer something else. If you reject it flat out, that it would proceed to hearing, which is set at the end of April, my understanding. And so those are your options right now. Barring any other discussion, I do think that staff has some questions as well, just to clarify for the record. So, but those are your 3 options today.
Would the hearing be with us or?
I believe the hearing is at OA,
OA?
which is set for April 29th or something, 25th.
Okay. What were the staff questions?
Mr. Hargraves answered a lot of our questions already, but I just wanted to acknowledge what Mr. Rain had said, that we did pull him into our conference room on the side there to have a discussion about the gravity of the situation. And it might have been Mr. Rain's option to look at the screen for 30 seconds. We didn't put a time limit on that. As he is legal counsel for Mr. Jada, he had the right to see what we had, and we wanted to entertain that discussion and to see what we can do to remedy the situation ASAP, as it was a serious matter. So again, we didn't set a 30-second time limit, and you have 30 seconds to look at the screen. So I just want to correct that for the record.
Just as a matter of discussion, I feel like this case is not like other cases. It's the longevity, the egregious amount of medications that are put out into the public. It makes it different for me, and my thought is to proceed with the hearing.
I concur with that. The 77,000 is extraordinary in my mind.
Mm-hmm.
I'm glad to see that he has gone for the evaluation and that he's getting help. But to me, it doesn't negate the underlying conduct. So I would be supportive of moving forward to hearing. I don't know that I'm prepared to offer an alternative agreement today, but I think we could get to that at the point of a hearing. So I'm kind of in the same vein. I do appreciate and respect Dr. Faria's commentary, and we get a lot of evaluations from her. So to me, her evaluation is not in question. It's to me the underlying conduct around the behavior that really I feel like we also need to really consider because of the egregiousness of the nature of the actual events.
Madam President, if I may, just for the board's edification, keep in mind that if this goes to hearing, then it will be a recommended ALJ decision that will come back to the board to accept, reject, or modify. So you can reconsider it at that time, given what occurs during hearing, as well as whatever your outcome is with the ALJ decision, is then the respondent would have an opportunity to file a motion for rehearing review, which would again come back to you. So there are several steps in the process where this will come back for you to reconsider.
Thank you.
I had a question. So if it does go to hearing and all of the facts are discussed and an outcome is decided, that outcome could still be a PAPA contract, correct?
It could be the ALJ could recommend revocation. The ALJ could recommend suspension or some other type of an agreement for the board. And again, that would be at board's discretion. Again, you have the statutory authority once it comes back to you to accept, reject, or modify that recommended discipline.
I'm willing to make a motion. I just don't want to cut off conversation.
Any other questions or discussion from other board members? Go ahead, Ms. Nair.
Okay, I'll make a motion to continue with the planned hearing.
Do we need to reject the?
There's not a formal settlement offer before you, but if we would just make the motion to reject respondents' settlement offer and proceed to formal hearing at OWA.
Okay, I make a motion to reject the.
You can just say, as she said on the record.
Okay.
Perfect.
So moved.
Second.
That's my motion.
I have a motion and a second. Any further discussion? Dr. Gandhi.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
I
Ms. Walmsley,
Aye.
Ms. Lehan's recused, Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you. This concludes the matter. Yes, Ms. Rain.
I was going to ask that you might consider one other procedural issue. As I noted, we anticipate that even through the hearing process, that Mr. Jetta won't be able to participate to defend himself in a way that could result in findings other than what you're going to present becoming the order. So I guess it occurs to me that as one opportunity to save the state the resources and the time, that if you would consider a motion authorizing the director to enter into an agreement for the surrender of the license, should we get to that point, we wouldn't need to bring it back to you. That's, a pretty typical thing to do, standard surrender agreement. It occurs to me that we could save some time if he had that in his authority, delegated authority to do at some point. We could take care of that if that's the way that the case goes.
Mr. D, I'll take your guidance.
Sure. So that would be, I would recommend that the board hear what the state would have to say about that as well. And keep in mind that any type of surrender, and staff can correct me if I'm wrong, any type of surrender wouldn't be reflected as discipline, as a revocation. So other states would not recognize that as a revocation. It would just be a voluntary surrender. Dr. Gandhi, can you speak to that, please? just the difference of a status.
Actually, I think my impression was a little bit different. In discussion with other states during our national meetings and stuff, most states recognize surrender to be in line with revocation.
This is Jean Galvin on behalf of the state. A voluntary surrender as a result of a pending complaint is reported to the National Practitioners Data Bank, and it is characterized as a surrender. A revocation.
And
Thank
Madam
you.
Chair, just in case it's helpful, we would acknowledge that it would have been discipline and equivalent to a revocation in most states' eyes.
Thank you. Ms. Didia, should we make this a consideration? Is that something that we can do at this point if that's what other board members feel is appropriate?
That is
Um,
at the board's discretion. Again, I would just ask what the state's take on that would be.
Ms. Galvin, Mr. Hargraves, are you prepared to discuss that?
Discuss what?
If we decided to entertain Mr. Rain's suggestion of allowing a surrender if we get to the point where that is
My only concern would be whether this is an attempt to severely water down these very severe and serious allegations. If that's going to be the case, I think it should come before the board. But that's just my opinion.
Thank you. Would we have the opportunity to consider that at a later point in time? So we've got another meeting, I think, between now and when the hearing is set forth. So could Mr. Rain bring that forward as a request at the April meeting if that's the case?
Could, as well as this is going to come back to the board with the ALJ recommendation. So at that time, you could entertain, voluntary surrender also in lieu of whatever the ALJ recommends. For instance, if the ALJ recommends revocation, then at that time, the board could entertain, instead of it being a revocation, that will agree to a voluntary surrender.
My
You don't
concern,
have to discuss, you don't have to decide right now.
my concern is the allegations, I feel like should be tied to his license, so it's clear as to why. So when you look up in the repository through NABP, it's clear as to why these actions were taken. And I feel like if you surrender, it's kind of a mystery as to why, rather than documenting why.
So, sure, go ahead, Dr. Gunn.
Madam Chair, if I may, obviously we did a summary suspension, and if the surrender, the language is in line with the summary suspension, I think we're all in agreement that was pretty accurate. If it's in line with that, I think it may be okay to entertain that discussion.
Well,
Almost, if I
all
may.
of this is public record anyways, so it's not like there isn't a record of what the
Correct.
concerns were. Ms. Galvin?
From the state's perspective, it is true that whether the state would be in favor of a consent agreement for voluntary surrender very much will rely upon the nature of the facts. While he was summarily suspended, it's the state's position that that was very early on in the state's and the board's investigation. And you can look at the document that summarily suspends him and compare that to the complaint and notice of hearing that has been issued. And you can see that the findings and how they outline the allegations.
And Madam Chair, if I may,
Yes.
Madam President. Just to clarify, I was not anticipating a drastic rewrite of the state's allegations of unprofessional conduct and alleged violations of law. I expect them to be almost verbatim in a surrender agreement. Sometimes in a surrender agreement, you might have a clause at the beginning that says that a licensee, while not admitting specifically to any facts or legal conclusion, acknowledges that the board has evidence from which it can prove these. We call that kind of a quasi non-admission. The reason that's valuable is, of course, for the reasons I've discussed, why Mr. Jetta wasn't able to talk to you today openly. So for what it's worth, I'm sure the directors heard your sentiments, and I want you to know it's in line with what I had in mind. It's going to say what the complaint says almost entirely, and he could, of course, reject it and say, I can't come to an agreement with you if we were trying to take a different path. So The other problem with coming back in April is that by April, we need to be getting ready for that hearing. The state's gonna have to do a lot of work. There's court processes. I'm really just trying to avoid any of that if we get to that point. But if we need to come back in April, that's okay too. But I am sure we could work with the director, and if we tried to, drastically modify what is the clear message from this board as to what it would want in that order, then he could just tell us, no, that's not what the board wanted, obviously, and I agree.
Madam Chair, obviously, I'm not an attorney by trade, and so I can entertain into that discussion if the board wishes that, and of course, seek legal guidance from the Attorney General's office. This is a state's case as well, and maybe one thought would be to seek their advice whether they're in agreement with the surrendering of the license, the language as well. That's an option.
Madam Chair, I'm sorry.
Yes.
One clarification maybe that makes, may make you feel a little more comfortable is that the agreement has to come back to you for final approval. And I guess, I would imagine by April, what might have happened is we've decided we're not going to go through with the hearing. We've negotiated the format of a surrender agreement, if that's where it goes. And if we're all in agreement, the state's attorneys would be in agreement. Director Gandhi would be in agreement that it is sufficient. Then we would just be presenting to you that signed agreement. If not, then we probably wouldn't be on your agenda yet because we couldn't come to an understanding. And I mean, maybe we'd show back up and say why we couldn't come to an understanding still to try and avoid a hearing. But I want to be clear. This is 100% solely to save the board's resources. If you don't want to do it, it doesn't change our world, really. It really does just serve the state. So if they're not interested, that's fine too.
Thank you, Mr. Rain. Board members, thoughts, discussions?
I'd rather not do it.
At minimum, I think we should have some time to look at work out the details. So at minimum, allow them to come back in April we'd have some time to investigate the ramifications.
Madam Chair, if I may. The hearing is set for, I believe, a full week beginning April 29th. There are some pre-hearing dates as far as disclosure exhibits. If the parties can reach an agreement that can be brought back to you at the April meeting, I'm sure we can stipulate to a continuance of the hearing dates to allow the board to consider that, so we don't have to go through all the time and resources of preparation. And maybe have it scheduled for a status update with the administrative law judge on the first day of scheduled hearing, where we would determine whether we need to set further dates or not.
That seems like a fair compromise to me. Mr. Rain,
Yeah, that's fine. And what I'm hearing as well is that the state and its attorneys would be willing to, have an exchange to prepare something for your consideration without a specific direction for you to do that. Sometimes they say we can't, the board hasn't directed us to engage in that settlement. So it sounds like we're all on the same page
Okay.
and we'll work together to be efficient.
okay, sounds like a fair compromise to everybody then. So no additional action is needed, it seems? No, we've already taken action.
Right, so just to clarify for the record, so the board is sending this to formal hearing, which has already been scheduled, and in the interim, giving staff as well as the parties an opportunity to reach some type of a settlement agreement, possibly for voluntary surrender. Is that my understanding?
Does that require a motion?
I think that the direction is okay. If you would like to do a motion, we can do that, and it could just be a voice vote.
I would
Okay.
appreciate that.
Okay, sure. Okay, so that would be the motion would just be that proceed to formal hearing at the end of April, and in the interim to have the parties and staff entertain an opportunity for possible voluntary surrender.
So moved.
Do I have a second?
I second.
Any discussion? Frank, I see you're moving to the mic. No, no discussion. Maybe we should do
Do a roll call.
do
then,
a
if
roll
we're gonna
call
have a
then.
sense. Thank you.
We may not have consensus.
Mr. Thorwald,
Nay.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan's recused, Mr. Dang,
Aye.
Ms. Al Nassif,
Aye.
Mr. Anderson.
Aye.
The ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Thank you both for being present today.
Thank you.
I appreciate it. I'm getting a request for a break, so let's take 10 minutes.
Can you unmute the boardroom, please?
Do you want to take roll call again, since it doesn't sound like the public could hear us?
Certainly, Madam Chair. Mr. Thorwald,
Here.
Ms. Snare,
Here.
Ms. Davis,
Present.
Ms. Walmsley,
Here.
Ms. Lehan,
Present.
Mr. Dang, Mr. Al Nassif.
Here.
And Mr. Anderson.
Here.
Thank you, Dr. Gandhi. Item 31A, since we have already addressed this item via a consent agreement yesterday, I'll take a motion to vacate this hearing.
I move we vacate item 31A.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none, motion carries. We will move to item 18A, which is a non-resident pharmacy permit requiring board approval, We Care Pharmacy. Good morning, Mr. Jacobson.
Good morning, Board of Pharmacy. Max Jacobson, Compliance Officer for the Arizona Board of Pharmacy.
Thank you. Do we have anybody present from We Care?
Hello, yes, my name is Amanda Jeffries. I'm the compliance officer for We Care Pharmacy.
Thank you, Ms. Jeffries. I'll let Mr. Jacobson provide a summary of the case, and then we'll come back to you. Thank you.
Thank you.
This case involves a non-resident pharmacy permit application that you all heard at the last board meeting. There was some discipline disclosed on the application, including issues involving a C2 inventory, sterile compounds being supplied to locations not permitted for dispensing, not maintaining reports for patient safety, and technicians compounding prior to completing the media fill testing. This board requested the most recent state board, home state board inspection, and we did get that information from the applicant. There were findings in the areas of general pharmacy and staffing having to do with ratios of technicians to pharmacists. Also continuing quality improvement, missing reports 3 of the last 12 months, general operating information, including compounding using ingredients in violation of one of their statutes. And manufacture date of a COA was incorrect or documented incorrectly on the compounding log. In the area of environment, there were eye drops that were not packaged properly. And in the areas of garbing, there were no surgical scrub being used.
So just, I guess, to recap, so this was before us at the last meeting. We decided we were going to approve it if we received a satisfactory home state inspection, and it wasn't, so that's why it's back here before us. Ms. Jeffries, if you'd like to make some opening comments, otherwise we can proceed with questions. I'll take your direction.
We can proceed with questions.
Board members, questions, discussion?
Can you talk about your latest inspection and the violations that were brought up and what you've done to mitigate that?
Yes, absolutely. So one of the deficiencies that were found was that the state of Virginia does have a pharmacy to technician ratio, which is 1:4, or I'm sorry, pharmacy or pharmacist to pharmacy tech ratio, which is 1:4. I believe that day there were 2 pharmacists and 11 technicians. Since then, we actually had one of our part-time pharmacists become full-time. So we currently have 12 pharmacy technicians and 3 full-time pharmacists. So that's what we did to remedy that deficiency. For the deficiency 27 listed, which was the compounding of semaglutide, that deficiency was actually removed by the Virginia Board of Pharmacy. We were able to provide everything that they had asked for as far as a C of A from all of the manufacturers. So they had proceeded to remove that deficiency from that inspection report. And then also to help kind of remedy that, we have better record keeping of all of our C of As. One of the issues was that we weren't able to produce the C of As on at the time of the inspection. So now we do have a better record keeping of all of our C of As. That way we can produce it anytime it's requested. For the QA, the quality assurance program, we have an in-house program. It is now taken over by myself and our PIC Swan. She is, we go over this and we review it almost every day. We go back and we look at it and make sure that there's anything that we need to work on or document regarding any QA, QC issues. So that's one way that we have remedied it. As far as the other two, so the blood products, those were comments listed in our inspection report. We have, because we cannot accommodate, our labs cannot accommodate having a complete separate area for those compounded products, we have decided to discontinue compounding those eye drops that contain those blood products. And then as far as the surgical scrub, we purchased surgical scrub and put it in all of our compounding areas. Does that help answer your questions?
I see that you have several different orders from various different boards. Have you complied with all of the orders? Like, for example, I see in the Virginia order, I think from 2022, that they ordered that We Care Pharmacy shall secure external training from a board-approved subject matter in compounding. Have you complied with all the orders in the various different states?
Yes, we have complied with all of that.
I have a question. What sort of sterile training do your compounders undergo?
So we go through Critical Point, an online program. We have them complete that, and then we also have our in-house competency assessment that they go through.
And all of your compounders perform 3 media fill and glove fingertip tests before they're allowed to do any sterile processing?
That's correct.
How often are your compounders doing media fill testing?
Right now, because of the new USP 797, they are doing their media fills quarterly. So every 3 months we have them do that.
Any other questions, board members?
It seems to me that they definitely had some deficiencies on their inspection. It was a 46-page inspection, so it seemed like a big list, but in the hundreds and hundreds and hundreds of questions, percentage-wise, they were, mostly compliant, and the deficiencies they've had, it seems that they've remedied based on the responses here today.
So you're comfortable with approving at this point?
Yeah, I think I'm comfortable. I'd make a motion to approve the non-resident permit.
Do I have a second?
Second.
Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, thank you for your appearance and best of luck to you. We'll move to item 24A next, and I'm recused from that, and I'm recused from the next item as well on the agenda, so I'll give it over to Ms. Davis.
Okay, we're gonna take item 24A, which is a pharmacy technician trainee registration for Austin Harper. We have someone from board staff here. Would you please introduce yourself and give us a summary today?
Brianna Washington. On November 30th, 2023, Mr. Harper applied for a pharmacy technician trainee registration. Mr. Harper previously held a trainee license with the board from July 2020 to January 2021. On or about January 5th, 2021, board staff received a notice from the Arizona Department of Public Safety indicating that on December 29th, 2020, Mr. Harper had been arrested by the Maricopa County Sheriff's Office on 2 counts of misdemeanor and DUI and drugs for an offense that occurred on or about January 15, 2020. Mr. Harper failed to disclose his charges when he applied for a trainee license in June 2020. On February 4, 2021, he signed a consent agreement to voluntarily surrender his license. Mr. Harper would like the board to consider granting him a trainee license, a registration. Sorry.
That's okay. Perfect. Thank you. I probably should have asked, is Mr. Harper here today? All right, do any board members have any questions or discussion regarding this?
This doesn't make sense to me. If he voluntarily surrendered his license, I don't think that we should just reinstate it by giving him a registration. I don't see any reason for that.
I would also think if it was important enough that he would be here.
Agree.
So can I just move to decline the request.
I'll second.
Okay, I have a motion and a second.
So that would be to deny his application for registration.
Yes,
And that is based upon the fact that he had his technician training license surrendered.
surrendered voluntarily and.
Okay.
Correct.
So amended.
Would you like a roll call?
Yes, please.
Yes, please. Mr. Thorwald,
Aye.
Ms. Snare, Ms. Davis,
Aye.
Ms. Walmsley's recused, Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you very much. Okay, so the next case we have is 26E, complaint number 23-0331. Thank you for being here. Will you both please introduce yourselves for the record?
Good morning, board members. My name is Jenica Brown. I'm the program manager for the PMP.
Good morning, Susan Trujillo from Corals and Brady. I'm here by myself this morning, but I do have a number of people online that I'd be happy to introduce now or at the beginning of my statement.
Yeah, let's introduce them now, please.
Okay, thank you. We have Renee Ramos, District Manager, Gina Sorrento, Business Analyst from Pharmacy Regulatory Systems, Aaron Greenwell, Healthcare Supervisor, Mike Simcoe, Senior Counsel, and Richard Rago, Director of Healthcare Compliance.
Thank you. You might have to remind me of some of those names.
Understood.
Can we start with board staff? Give us a summary of this complaint.
Absolutely. In June of 2023, board staff received a complaint from an Arizona licensed physician assistant alleging that her patient's PMP report did not contain narcotics that were dispensed to the patient for the prior 6 months. She stated that she notified the pharmacy and spoke with the pharmacist in charge, but the situation had not been rectified despite her many efforts. Board staff ran a PMP report for the patient named in the complaint and contacted the complainant to confirm prescriptions that were allegedly missing from the report, which she indicated as multiple prescriptions for Belbuca, a Schedule III controlled substance. Board staff then contacted the respondent, spoke with the pharmacist in charge, and requested a response and supporting documentation to the allegations. The respondent provided board staff with pharmacy records for the patient and evidence of an open ticket with the Walgreens corporate office regarding the controlled substances that were identified as missing from the PMP by the complainant. Upon review of the pharmacy records, the complainant's allegations were substantiated, as the records indicated that several Belbuca prescriptions were dispensed to the patient, while only one of them appeared on the patient's PMP report. Board staff also identified that there were 13 additional controlled substances within the pharmacy records that were missing from the patient's PMP report, including multiple opioids and benzodiazepines. Board staff discussed this finding with the pharmacist in charge and encouraged him to update the ticket to ensure all controlled substances that were dispensed to the patient were properly reported to the PMP. In early July of 2023, the pharmacist in charge notified board staff that the ticket to fix the missing data was resolved and the controlled substance dispensations were properly reflected on the patient's report. Board staff confirmed the corrections and contacted the complainant to also verify that the updated record was accurate to her knowledge, to which she affirmed. What you have before you today for discussion and consideration is a potential violation of Arizona Revised Statute 36-2608A, which outlines the requirements for reporting Schedule 2 through 5 controlled substances to the Arizona Controlled Substances Prescription Monitoring Program.
Thank you. Ms. Trujillo, would you like to respond?
Yes, please. As the investigator just noted, this patient's file has been confirmed to be current, based on consulting with the complainant. So why we're here today is the Complaint Review Committee had concerns over whether this was an isolated issue or some sort of systemic issue. And in response, this was in fact an isolated issue. Walgreens has used this opportunity to make some improvements in its PMP program. It is confident that going forward, this particular issue will be addressed. So in response to this particular issue, Walgreens initiated a root cause analysis to determine why these files weren't making it into the PMP program. It reviewed the file rejection information that it was receiving from SureScripts, which is the vendor that it uses to port that information into the program. And an analysis of that data showed that this problem was actually related to the Kentucky prescription monitoring program. So Kentucky, this patient had moved from Kentucky to Arizona. And as part of her move, some of her data had moved from her Kentucky file into the Arizona file. Kentucky requires the patient's social security number to be reported to their PMP. And during that porting process, somehow a number was accidentally deleted from her social security number. So that when Walgreens then submitted the patient information to the PMP through SureScripts was rejecting that file because that number wasn't complete, even though it's not required in Arizona. So the PMP program at Walgreens was able to realize that that was the issue. It's corrected that, and then it's also implemented new processes to make sure that the SureScripts rejections are being reviewed on a daily basis, so that any other anomalies that pop up are being promptly addressed.
Thank you very much. Board staff or board, do you have any questions for either party?
I have a question. Are you aware if isolated case, or do you have any complaint or concern about reporting from Walgreens?
We are aware of concerns of this nature. Unfortunately, in this situation, it relates to data that is omitted from PMP reporting. So essentially, we don't know until there is a complaint brought to us. We do have people from time to time that will contact us to let us know that with other locations with this company, they do notice PMP records are missing. We don't have any substantial evidence that there's a systemic issue, and we don't have any open complaints at this time, but we are aware that concerns do arise.
So if I say a statement, would you agree with me? Like, we all believe there's glitches. Sometimes the system can cause those kind of issues.
In my professional opinion, that would be a possibility.
And there's always a potential that, a piece of data, submitted to the PMP, there's a typo or something that needs to be corrected. But that's, something that then comes back to new, to their program, and those issues are addressed. And one of the people on the call here, Gina Sorrento, is heading up that team, and she'd be happy to kind of describe what that process looks like, if that's at all helpful to you.
I don't have any further questions, but I believe this is just me. I believe Walgreens and all other retail, they're trying their best to be compliant with reporting daily. So, and I'm happy that you address the issue and you fixed it, and then you do daily review for those rejections. So I will move for dismiss the complaint.
Second that.
I had one more question. Walgreens didn't have a process in place to address these rejections previous to this, or was it a store by store process?
It had a process in place, but they've identified some gaps so that now they've got this team that's dedicated, to it, and they look at that on a daily basis.
So this rejection queue, I mean, how many, if it's isolated and we have a team dedicated for rejections, it doesn't seem isolated. Do you have data on how many patients and prescriptions are in this rejection queue on a daily basis?
I don't believe that data is tracked or available. Is anyone on the call able to answer that question?
Good morning. This is Gina Sorrentino. We head up the PDMP team here for Walgreens. We have people dedicated to handling all corrections. So it's not just specific to this one instance. This one instance was an outlier, and it's been corrected, and going forward, we will be notified by our IT team when we do receive rejects in the response file from our vendor for prescriptions they will not consume because there is a data issue on our patient.
And so to clarify that just a bit, they can get a number of different types of rejections from SureScripts. So it's not just linked to, a problem with the report to the PDMP program. It may be a problem with other data that SureScripts is processing for them as a prescription moves through, the system. So, as they're processing, rejections that come from SureScripts, there may just be, a couple that are related to a PMP issue, whereas, there may be, others that are related to other services that SureScripts is performing for Walgreens.
Building on that, I just wanted to make sure. So any of the rejects that need to be addressed, they're going to be by this team and not at store level?
Correct.
Okay. Yeah, I feel good about that root cause analysis to be able to determine really specifically what was wrong in this particular case, to get all the way down there to understand that it may not be something, while other times there may be certain additional issues that need to be addressed that are one-offs also, that you were able to determine it was not necessarily a store issue or a widespread issue, but very specific to that data being missed. So I feel comfortable as well.
All right.
So I give my motion.
Yeah, I have a motion and a second. Is there any other discussion before we take a vote? Okay, all those in favor of dismissal?
Aye.
Aye. Any opposed? All right, thanks for being here today.
Thank you.
Thank you.
Thank you, Ms. Davis, for taking over. We are going to, where next? 26F. Which is complaint number 23-0533, Curex. If the folks on the line from Curex could please introduce yourselves.
Good morning. My name is
Sorry,
Mark Taylor.
Curexa.
I am the pharmacist in charge and CEO of Curexa Pharmacy.
Yes, and good morning. I'm Julie Campion. I'm the Director of Quality and Regulatory Compliance.
Welcome. Thank you both. And I see Mr. Hyber has joined. Mr. Hyber, if you could introduce yourself and give us a summary.
Good morning, board members. Steve Hyber, Compliance Officer. This complaint involves a shipped medication that was received without protection from excessive temperature, and some of the medication leaked out of the container during the delivery process. The board received the complaint from the patient, who stated their order was exposed to excessive heat and leaked medication upon opening. The patient provided images, and those are in your board packet, of the labeled container. It also had a smeared label and dried white residue adjacent to the container's closure. The prescription was issued by a telemedicine practitioner and it was filled by the respondent pharmacy, which is located in New Jersey. So it's not in Arizona. The PIC of the fulfillment pharmacy provided a written response and stated that upon the compounding ingredients that were acceptable to be exposed to higher temperatures. The PIC also stated that they received information from the telemedicine representative that it could also be exposed to the temperatures that it experienced during the shipment. Our investigation identified the employees who processed the prescription. However, none of those employees are licensed in Arizona. The prescription was completed on June 22nd of this past year. It was received by the patient on the following day, June 23rd. The patient was a resident of Phoenix, and the temperatures on that day ranged from a low of 79 degrees to a high of 101 degrees. Just for your own edification, the USP defines control room temperature between 68 degrees Fahrenheit and 77 degrees Fahrenheit, with excursions allowed during shipping between 59 and 86 degrees Fahrenheit. Also, the label that was reprinted, we noticed some little defects with the label. It had some difficulty in reading all the required information on the label. The drug description was partially obscured due to overprinting, which is a common thing we see sometimes during inspections, and we just want to let the permit holder know they may need to change their output field alignment in respect to the label. And that's about it. If you have any questions, feel free to ask me.
Thank you, Mr. Heiber. Board members, questions for Mr. Heiber? Would somebody from Curexa like to make a statement before we proceed with questions?
Yes, thank you. Appreciate the board taking the time to hear us. Just from an order of dates, the prescription dispensed from Curexa in New Jersey was a compounded product that is produced under a heated environment, meaning the solution is heated prior to the drug being added to it. It is a topical hair solution, and this product was completed at our pharmacy. All the pre-dispensing checks were done at the pharmacy on June 20th. The actual product was completed, checked by our pharmacist, and shipped on June 22nd, and received by the patient around June 23rd. This complaint did not come in till September 8th to the board, which is about 2 months after the receipt of the product. And subsequently, we received the complaint from the board, which we responded to. I just want to speak a little bit about Curexa's quality control. We are a compounding pharmacy as well as a commercially available medication mail order pharmacy. And for the compounding piece, we do follow all USP 795 directions. And as far as packaging, all packages are reviewed once filled by a pharmacist, including the check of the top that would go onto the bottle to make sure it is very tight for shipping. Again, it is an alcohol solution mixed with propylene glycol, and this product was shipped. We shipped quite a few of these products into Arizona around those same dates and did not receive any other complaints. And this type of complaint is not typical of what we receive. Julie, anything you want to add?
I think you covered it well, Mark. Thank you.
Thank you very much. Board members, questions?
Since you've received this feedback about your labels that appear to be altered when a solution droplets fall on it, have you changed your labeling so that you don't use that same brand label?
We have. We've looked at two aspects of a label. One is the aspect of the wording and blending into the barcode. Our IT team has fixed that, so those labels are now no longer bleeding as far as wording into the barcode, making it a little more difficult to read. And then we have also sourced chemical resistant labels, which are resistant to oils and alcohol and things like that smearing the label, which we are now using.
Go ahead.
This product was in a glass container. What
Correct.
precautions do you take when you're shipping something that's in a glass container?
So glass containers, this product goes into a fairly heavy cardboard box, which also has inserts in there that hold the glass bottle in the middle of the box, so it's not bouncing around. It is also shipped, depending on the glass container, with bubble wrap or paper packaging. And we honestly really receive very few issues with the glass breaking or any other problems with it leaking.
Have you changed anything with regards to the way that you handle medications based on temperature sensitivity when you're shipping to places like Arizona, when it's so hot outside?
Well, I mean, it's something I think we'd ask the board for guidance on. Again, we are following the USP regulations and understanding that the Phoenix area gets very hot during certain months. And I think we are curious to hear what the board would suggest to help with that. One issue with this product is that if it is, for instance, if it was to be shipped with cold packs, the product does fall out of solution when it falls below standard room temperature. So that's a concern if we were to pack ice packs into it and then ship it. We very well are probably going to get complaints about crystallization of the products.
That makes sense. What else? Any questions, guys?
I do. What beyond use date do you put on this compounded product?
This product has a 180-day BUD.
Is that because it's an anhydrous compound or because you've ever performed stability indicating studies on the compound?
We have never performed stability indicating studies. It is an anhydrous product. We use anhydrous alcohol. We have performed potency studies on the product, which have been in spec.
Perfect. Potency over time or just day zero potency?
Day zero potency.
I know that minoxidil anhydrous is really hard to compound, and you do have to heat up the solution in order to get it into solution. Shipping it with ice packs would cause it to precipitate. Similar to the problem mail order pharmacies have, they're not shipping tablets that also have these same room temperature excursions, USP guidelines in, insulated boxes. So this shipping problem continues to be something that we have to think about as a board because of the extreme temperatures that we experience here in Arizona.
Yeah.
So when you have situations like this that are brought forward to your attention where there's a concern from a patient, how do you handle that?
So if the complaint comes to us directly, we would handle it, ask the patient questions. We would normally ship them a new product. I believe in this particular case, the patient reached out to the telemedicine platform that they had been working with, and that's where the complaint started. So by the time Curexa heard about this, it was already beyond the point of the patient writing a letter to the board. But normally we would offer the patient either a refund or to ship a fresh product overnight.
Thank you.
I'm leaning towards either a letter of concern or dismissal. I think that everything we've heard today shows that they take great care, take common sense measures to make sure their product is received safely.
I make a motion that we dismiss.
I'll second.
Any further discussion?
Just a question, Madam Chair. So for this particular product, you can't put in an ice pack and you can't really leave it without monitoring and controlling the temperature. So what is the solution for something like this?
I think a solution for something like this would be to perform a real-time study where you expose the product to extreme temperatures and then test not just the potency, but ideally the stability indicating assays of the product over time to be able to prove that temperature excursions, say up to 100 and some odd degrees, will allow it to still retain its potency. I would like to point out that this batch that this pharmacy made was 900 liters of this solution. So one prescription of 90 milliliters is a teeny tiny percentage of this entire batch that they didn't have any other complaints about.
And I think that that's, going back to our discussion on temperature, not to get too far off the rails here, but that's where this is such a complicated issue. And that's where, why we're looking at trying to solve this more broadly, because there isn't necessarily a one size fits all. And when we're talking about compounded products, manufacturers typically have those types of studies that are available that pharmacies can utilize to make those good decisions. When we're talking about compounded products, that complicates it even that much further. So I'm very comfortable with dismissing it. So any further discussion from the group? All those in favor? Aye. Any opposed? Hearing none, thank you for being present and appreciate you.
Thank you.
Thank you so much.
All right, next up is 26G, complaint number 23-0349.
Madam Chair, I am recused from 26G and H.
Thank you, Ms. Lehan. This is a case with CVS Pharmacy. If you would like to go ahead and introduce yourselves for the record.
Good morning, everyone. Brian Convery, CVS Health. I'm here on behalf of CVS 9293.
Good morning, State Board of Pharmacy. My name is Armando. I'm District Support Pharmacist for District 2 CVS.
Good morning, State Board of Pharmacy. My name is Benjamin Romero. I was the technician at the time.
Mr. Convery, the PIC is not with you today. Okay. Anybody
Hi,
else?
I'm here on Zoom. Sorry.
If you could please introduce yourself.
Hi, I'm Leanne Tran.
Thank you. Mr. Hyber?
Steve Hyber, Compliance Officer. This complaint involves a prescription that was misbranded, and the pharmacist failed to notify the prescriber that the prescription was dispensed for less than the prescribed quantity. Obviously, it involved a C2 for it to have that requirement. We received the complaint from the patient who stated their practitioner, their doctor, prescribed a medication that was going to last them 3 months. The drug was involved was Adderall. The patient was initially dispensed a 30-day supply in a container with 2 refills indicated on the label. And when the patient later returned to obtain the refill that was indicated on the label, the pharmacist refused to fill the prescription. The investigation found that the prescription was received by the pharmacy electronically. It was written for the XR version of Adderall for 15 milligrams, quantity 90, with directions 1 capsule every morning. The prescription was entered, verified, and it was initially placed on hold. It remained on hold for approximately for about 3 weeks. And then the technician that's here today relaunched the order. The prescription was filled and verified by pharmacist Morales, with the sale occurring later that same day. Counseling was not required. This was a continuation of therapy. A reprint of the involved prescription label is in your board packet on page 5174, and it clearly lists number 30 dispensed with 2 refills. The pharmacist in charge responded that the quantity of the drug was reduced to satisfy the patient's insurance plan, which would only pay for a 30-day supply at a time. The PIC also stated that anytime a C2 prescription is filled for less than the prescribed quantity, the pharmacy system would automatically indicate refills allowed. And in the case of a C2 drug, the patient would forfeit any remaining prescribed quantity for that type of reduction. Both technician Romero and pharmacist Morales stated they did not recall the filling of the involved prescription. No documentation was found indicating the prescriber was notified of the partial C2 fill, and the pharmacy DM also confirmed that the prescriber was not notified of the reduced C2 fill.
Thank you, Mr. Hyber. Mr. Convery?
Thank you, Ms. Walmsley. As Mr. Hyber said, the This instance unfortunately brought to our attention a gap in our system in how the label is printed. It is a gap that I believe, and I'll let the staff members speak for themselves, the individuals speak for themselves. We believe that it is something that our pharmacy staff, not just here, but throughout Arizona and throughout the country, have recognized and corrected on the spot or at the time. Unfortunately, this one slipped through and made us realize that there is an IT gap that we have. We are taking actions to correct that gap. We are aligning our system, or we will be aligning our system to comply with the federal regulation, with the federal CARA law, so that our system will kick out a 30-day refill buy on any of these short fills. Unfortunately, this is with Adderall. This was exacerbated, but brought to the forefront due to supply chain shortages with Adderall. Until that time, unfortunately, again, it was a gap. I can only offer my apologies for the fact that that gap was there.
When do you anticipate the system fix being in place?
I am told that once it is, and I had conversations last week on this with the applicable partners within the company, that probably within about 8 weeks, it should be able to get rolled out entirely, because that will include the IT fix, but also guidance documents and some retraining to go out to the field with regards to what the expectations are and what should be done to make sure all that's reinforced. So I'm told approximately 8 weeks.
Board members?
So CVS knew that this existed. Pharmacists and technicians reported this as a concern, and the local store had to manually adjust labels and inputs to reflect what they were dispensing. Is that what I'm hearing? So the CVS knew that this was an issue and is really not taking action until a board complaint is filed?
Mr. Addis, so to answer that question as easily or as simply as possible, when you say CVS, that assumes that everyone within the company knew. So yes, was there knowledge of this problem? Yes, there was. To the extent that the correct people were aware of the problem, or the correct people that could fix it, unfortunately, that's where we are now.
Why wasn't the provider notified that there was a decrease in the dose or quantity, excuse me?
Okay, so as far as I remember, I don't really remember even, like, usually when this happens, I'll let the patient know what's going on. Like it's a C2, your insurance only covers 30 days. I would let them know that if we fill for 30, you can't get the rest of it. Like, if we have to fill it within 72 hours, your insurance will cover it until another 30 days. So I would tell them that, like, the rest of it is, you can't get the rest of it. Also, I'll let them know that they have to contact their doctor and let them know what happened. Or they could pay out of pocket for the whole 90 days if they want to do that. But I actually don't remember ever talking to this patient. So I don't know if Ben remembers.
What's your general practice then? If you don't remember this particular case, what is your general practice if you decrease a quantity on a C2?
Because if I decrease, then I'll let the patient know, and then sometimes I'll say, "Oh, will you let my doctor know?" And also then I will contact the doctor. That's usually what I do. Yeah, usually usually the patient will say, "Okay, that's fine. I'll just talk to my doctors," and they kind of do it. But if they don't want to do that, then I'll definitely reach out to the doctor and let them know if we change something to 30 days.
So you're required to contact the doctor instead of putting that on the patient. You're the one that's required to do it. So hopefully you've learned that through this.
Yeah, definitely.
I have one more question. So when did you identify the issue? Who did you contact in CVS? Who did you reach out to?
It would have been the district manager at the time, and then the PIC, and then the PIC would have taken action on it. So I'm not too sure.
As a follow-up, Ms. Tran, have you ever reported this through any type of IT channels or any of those kinds of things? Have you ever reported this upwards?
No, normally I don't. Well, I've known about it since this issue has been brought to my attention. Normally with patients, when I fill for a decrease of what was prescribed, then I usually let the patient know I can either send a PR to your doctor's office to get a prior auth to get you the full quantity. You can pay for it out of pocket, or I can fill for what is covered, and then you forfeit the rest of your script, and then you just have to let your doctor know to send it in after that amount of days. They usually tell me to fill for what is covered, and then they will just lose the rest of their script. I personally, in my workflow too, I don't notify doctors' offices because in Arizona, they're supposed to be checking the PMP. No pharmacists that I know of in CVS also contact doctors. We just fill for what the patient is requesting, and then it's on the doctors to check the PMP for when they picked it up, or they can call us at the pharmacy and be like, hey, did you guys actually only fill a week instead of a month? And I say yes. But up until that point, I didn't realize that on the labels that they give the patients refills until this instance. So since then, I have changed my workflow to cross out the refill number, block it out, and let the patient know that they can't have any refills when I'm on duty. So
Thank you. So you weren't aware before this that there was this IT challenge?
no, whenever I go to fill C2s, I just circle the quantity that is on the label. I don't really look for refill numbers because technically they're not supposed to have them on the label if you fill for less than what is prescribed.
So just for clarification, so it's written for number 90, they dispense number 30. Is that considered changing quantity? Because they didn't change the original quantity, they dispense like less, right? Are they still required to contact the provider? Just to make to clarify that.
No, that's a good question. I think we need to talk about this because I'm somewhat confused with the length of time that this problem was in place, but I'll answer your question first. As everybody is aware, the CARA Act is rather new, although that's relative. It's been out there a year, but it takes time for these things to percolate through the various operations. And software needs to be built to support CARA. Honestly, I thought when I saw this complaint, I thought it was they had deployed their CARA software, but they hadn't communicated to their staff how to properly use it. Because the expiration date was compliant with CARA. It was a very short date because CARA doesn't allow for a long time period, like a normal control refill would be for 6 months. So I thought it might be, maybe they didn't communicate CARA, because under CARA, you can do a partial fill. And it probably would be labeled as a refill on the label. I don't know whether they'll go to a technology fix where they're going to say, partial fill or something. But those refills on this one, it wasn't compliant under the stipulated process for CARA. There's only two individuals that can request a partial, the patient or the prescriber. And if you read DEA comments, the DEA is going to want to have that documented somewhere. In other words, if we come in and do an inspection and we see that they've done a partial fill, we're going to be expecting to see either something on the prescription, a comment maybe on the electronic one from the prescriber, or some documentation in the patient record that the patient requested it. A reduction, like in this case, for a insurance purpose is not eligible for CARA. So that should be put in for the quantity that the patient has agreed to get. They can get the full quantity if the pharmacist wants to dispense the balance under cash. They could get partially billed to insurance and the rest to cash. Or the patient says, I can't afford that extra money for the non-covered component, then that's forfeited. And the rule requires the prescriber to be notified of that partial fill. Otherwise, the patient's going to be going back to the prescriber going, hey, I need another fill. And they're going to think, hey, there's something going on here. That's why that was put in the law. So if this really had been happening, as long as I'm hearing, we should have had a lot more complaints because people would want to get their balance of their C2. You can guarantee that, especially if it said it on the bottle. So I'm almost thinking this was an early deployment of CARA without anybody knowing about it. And then we finally got wind of it when this patient didn't get their refills.
I would agree with you. Yeah, because I'm aware of companies trying to be compliant with CARA. So I would agree with that.
Mhm.
So just my question to PIC. So when this problem brought to you, did you contact anyone from CVS?
Well, with the complaint, I didn't know about it until the board had contacted us, I believe, or my DM had reached out to me about it. But I hadn't been in my store all weekend when this occurred. So I was just notified and briefed on it when I got back. So I'm not sure.
And I just want to say one more thing too, like I wouldn't even change it to 30 day. Like if I change it to 30, I would contact the patient for sure. Like I wouldn't ever fill anything, like change the quantity and just fill it without even telling the patient to. That's why I'm kind of like confused. I don't even know how this happened. Like I don't even remember if I was the one that talked to the patient. I don't know who even talked to the patient to change it to 30. But that's why I'm kind of confused too a little bit.
So I think there's a good lesson in documentation for everybody in the audience here, which is the good thing about people coming to board meetings, right? There's a good lesson here. Understandable that system things take time, not great communication with the patient in this case. We failed to live up to the expectations of what the patient expected on the label, and perhaps there wasn't as good of communication when they picked it up in this particular case. But I don't think anybody intended for there to be anything bad to occur here or any of that kind of stuff. But I do think that this is a really good lesson for everybody around documentation. So
Madam Chair, if
that's
I may ask.
my
a question.
points.
Building off of Mr. Anderson's question, Mr. Convery's answer, Mr. Convery, I think you said the appropriate people weren't contacted. What is?
Yeah,
when a
and let
store-
me, like, if I can clarify.
Absolutely, please.
And I apologize, Mr. Anderson, if I answered incorrectly or I answered partial correctly. The CARA, this complaint did not make us look at this and say, oh my gosh, their system is a problem. The CARA, as Mr. Haber said, CARA is relatively new, but it's been out there. We recognize that the CARA issue, and we've been working towards the IT solution on the CARA issue. But the 8 weeks that I answered Ms. Walmsley, we're expediting the rollout in Arizona, but we've been working on the IT issue, but we're expediting in Arizona. So we did recognize that the issue was out there. I apologize if I led you to believe that we didn't even know the issue was out there. We have been working on the CARA upgrade.
So what that will make a difference if it says 60 tablets remaining instead of two refills. It's just the verbiage of the label, right? It was kind of confusing.
I'm not going to opine on the label, whether it should say refill or not. I think, we might have to get feedback from the DEA on that if they don't like that, or our own board says they want to see certain language. I mean, the fact of the matter is, if it's reduced because of a CARA request, then that label probably would be okay. If it's reduced for any other purpose, then they need to follow the law in respect to a reduction on a Schedule II, and that includes notification of the prescriber. The law doesn't say you notify the patient. I think it's a good customer service issue, though, because you're going to get a complaint on that as well if you don't.
Correct. And part of the guidance, part of the guidance will be, I believe, to make sure that it is reiterated that the prescriber is contacted.
Yeah, so I mean, I see that happening. I mean, I see like there is trying to do their best, but I agree that as a courtesy, you should have at least call a patient, right, to be both on the same. That's at least our patients owe us time and courtesy call. They need to understand what's going on. We cannot leave them just on the dark and then they get surprised with no answer. They cannot do so, but I believe that hopefully you learned the lesson. So I will be fine with a letter of concern.
I was kind of thinking maybe something a little bit different. I was going to lean towards 3 hours of law CE for the 3 licensed individuals that are listed, since it looks like there was a little bit of opportunity for education here. I think they probably learned a lot, but I think to memorialize that, I think that would be good. And then perhaps just a letter of concern to the permit holder is where my head is right now.
Exactly what I was thinking.
I'm sorry, can I ask a question though? So for any retail pharmacist, especially for patients who are on access plans, for example, when they are opioid naive or they get a different type of C2, most insurance will reject it and say like, oh, you can only fill for a week at a time. So a lot of the times patients will take that week and then dismiss and forfeit the rest of their prescription. So you're telling me every retail pharmacist has to do that for every access patients, because that's going to be a lot of time on the phone, which, like I said, if you ask any like CVS retail pharmacists that I know of, no one contacts any doctors about those things. Doctors check the PMP and then they fill their next prescription for that. So I'm not aware of contacting doctors. I haven't had to do that in the 2 years that I've been a pharmacist here, and I'm not going to lie to you. So I don't know where that has been reiterated to us as pharmacists. Maybe that's like a district manager, regional manager issue for not training us properly on that, but I haven't ever had to tell a doctor that I'm shorting a patient, especially based on insurance, which is what this issue is.
Does staff want to make a comment on that, or do we want to address that offline? Okay, so we'll need to take a brief break then, and
Yep.
so we can get back online.
Absolutely, and then we'll have an answer for you at that time.
All right, let's take like 10 minutes. Do you think that'll be good enough?
10 minutes enough?
Okay. Apologize for stopping right in the middle of this, but
I don't, okay, so I don't think that the budget is bad. And I left them with the office and I texted her, I think she's sleeping. She was.
I don't want to call. I know, that's why I didn't say anything. Complicated.
All right, welcome back, everybody. Apologize for the technical difficulties. We lost just a couple minutes of video. We went back and kind of watched that. So I'm going to give a brief recap since the public missed part of the discussion here in the room. So during the time where we were out, there was kind of two pieces of discussion that were missed. Ms. Tran, the PIC involved in the case, asked some questions around how the CARE Act works and its intersection with insurance requirements and documentation and some of those kinds of things. So I'll have Inspector Hyber answer those questions here in a moment. The other thing we started to kind of formulate the thoughts of a motion. I'll have Inspector Hyber address the questions first, and then we can go back into discussion on kind of where we think we want to go from a motion standpoint. Does that sound good, everybody? All right, Mr. Hyber.
All right, so rewinding the clock back a bit. I think the issue here today involves the partial filling of a Schedule II prescription. And we really have two issues in play. We have Schedule II prescriptions now, at least insofar as the retail setting. We're not talking long-term care or hospice or anything like that, where partial fills have been in place for many years. But for a regular patient walks in the door at a retail setting and they present a Schedule II, or it comes in electronically, a Schedule II, if the patient or the practitioner requests a partial fill on that Schedule II, then that prescription can be partially filled. Okay. In this case, what we had a prescription that came in electronically, and it was partially filled. The patient did not request it, and I confirmed it in this case, just so you know. I talked to the patient in that regard, and the doctor didn't indicate on the prescription for a partial fill. And the insurance company in this case, which is very typical in a retail setting, would only pay for a portion of the total quantity prescribed. In that situation, when the pharmacy has to reduce it because of an insurance reason, or an out of stock might be another reason, the pharmacy has insufficient stock, then that prescription, basically the patient, if they accept that lesser quantity, then the balance on that issued C2 prescription is forfeited. And by federal law, under 21 CFR 1306.13a, little a, it talks about the partial filling of a prescription. Again, we're not talking about Cara now. It is a requirement for the pharmacist to notify the practitioner of the partial fill. Okay, there's no exceptions to that. It doesn't matter if the patient, if it's on insurance, it doesn't matter if it's cash, it doesn't matter at all. It doesn't matter if it's Medicare, Medicaid, or Access. It has to be, the onus is on the pharmacist to notify the practitioner. And they probably should document that in writing as well. Good idea.
Thank you for that, Mr. Hyber. Board members, additional discussion, thoughts on a motion?
Madam Chair, I just have a clarification question for Ms. Tran. Ms. Tran, are you still on the line?
Yeah, I am.
Okay, so earlier you mentioned that for all Access patients, Access only cover for 10 days supply of narcotics, a week supplies of narcotics.
Yeah, it depends on what type of C2 that they are getting. If it's brand new to them, most Access plans will only allow a 7-day supply before they will allow the patient to have a full month supply. Sometimes it is the same thing if they are taking the same drug and have been on it for a while. So it just depends on the plan. I'm not exactly sure because that would be their insurance's formulary. But for most patient access plans, if they are the first time on that drug, so if the doctor calls in 10 days and the insurance will only cover 7, in my workflow, I ask the patient, do you want the 7 days? You lose the rest of your script. Do you want a prior authorization to get the full 10-day supply, or do you want to pay for it all out of pocket, which they can't because they are on Access? So the prior authorization needs to be denied first before they can pay in cash. So
Okay.
that's how that happens.
So, and for all initial C2 narcotics, they're only covered for 7 days by the Access plans. So that is the common knowledge or common information that all prescribers should be aware of, correct?
Personally, I'm not sure what doctors know and what they don't know because, like, for example, for Medicare Part B as in boy, most doctors should know that patients who are on insulin, they can get a max of testing their supplies 3 times a day. If they're not on insulin, it's 1 time a day. So like patients, or like if Medicare Part B needs diagnosis codes to be billed, you would think doctors know that, but they don't. So I can't speak for them on this part either.
Okay, so my last it's not a question, but more of a statement. Mr. Haber had mentioned that there's a federal law that we have to abide by as pharmacists. Regardless whether or not the physician are aware of the 7 days coverage or not, it is ultimately our responsibility to notify them.
Okay, I will say that I was not aware of that, but with respects to that too, how do you want us to notify them? Because getting a hold of us as pharmacists is much easier than getting a hold of doctors' offices. By the time you finally get to somebody, they will tell you, oh, let me put you on hold, or we will have to get back to you, or I'll take a note for the doctor. And sometimes they don't even call us back. So I would like to know how you would like us to go about doing that if we are supposed to notify doctors, because if I have to do this for every single patient in my pharmacy, I will probably have to be on the phone all day long.
Mr. Hyber, I think the law is silent on how that has to occur, and I think there are some systems in place that do automatic notifications for the pharmacist as well.
Yeah, a lot of the mail order operators have bounce back systems for that purpose, and utilizing fax is probably the most efficient way. I would admit that the phone would probably not be too effective. But again, I think it's not the place of the board to kind of opine on that. The law is the law. We enforce the law. And if you don't like the law, maybe lobby to have it changed.
But the law is silent on how that notification
Yes,
has
it
to
is.
occur.
It doesn't go into that level of detail.
Okay, thank you.
I'd just like to add also, just notifying provider not getting approval, just to let them know that what we did. So the law doesn't say how you do it, but I was okay with the letter of concern, but since there's a law issue now, and there is a gap of knowledge, I would agree with the CE, 3-hour CE.
I'll officially make it my motion. 3 hours of non-disciplinary law CE for the PIC, pharmacist, and technician involved, and a letter of concern to the permit holder.
Do I have a second?
Second.
Any further discussion?
I think letter of concern to the permit holder is on the light side, in my opinion, just because the permit holder should be held accountable for coaching their pharmacists to make sure that they are abiding by the law. So in a sense, the permit holder, in my opinion, is taking the law lightly to some degree.
My thought on that is this is something that's new, and their system, they're working on improvements, and it may or may not be in compliance at this time, depending on how we're viewing the law, interpreting it.
What I've interpreted, Ms. Nair, from what CVS's legal counsel has said is that they have not implemented these changes yet. So this is in current state. So I'm with Dr. Dang on I think a letter of concern is a little too lenient for the permit holder. I think that the configurations in their system that the permit holder controls need to be modified more rapidly to support the pharmacists in making appropriate legal decisions dispensing drugs.
So maybe let's take the pharmacy and the team members separately then. Are you okay with amending the motion to separate those two things?
That's fine.
Whoever made the
Yes.
motion in
I
a
made
second.
I made it, and yes.
Okay. So with regards to the pharmacists that are named in the technicians, the motion on the floor is 3 hours of continuing education for law.
Yes.
Correct?
Yes.
Non-disciplinary.
Non-disciplinary. Any discussion on that? All right, all those in favor?
Aye.
Any opposed? Hearing none, motion carries. With regards to the permit holder, let's jump back into discussion.
Okay, so one thing to me I was hearing is that once you are aware of it, you're correcting it. So I don't know what else we can expect of the permit holder than to react once they're aware.
I heard testimony that they had known about this for quite some time. And that the pharmacists at the store did workarounds to manage this gap that CVS did not necessarily support in their IT configuration. So I think CVS did know, they acknowledged they knew, and did not act quickly enough to have a compliant label.
Yeah. Well, in my opinion, I know that there's plenty of IT consultants out there who could assist CVS corporate with this issue so that CVS as a corporate would be compliant with the federal law. So I think they need to act on it and take it seriously because it's a federal law that their pharmacists are not compliant with.
Or the minimum, just send email to all staff that we are aware of this issue. Please keep eye on those labels and do adjustments appropriately. But I agree, they didn't even do that. Didn't send an email to any PIC or staff to address the issue.
How long has CVS known about this problem?
Unfortunately, I can't answer. I don't know the answer to that question. I apologize.
I
As I,
do-
as I stated, and I believe it was off the record, we are, as Mr. Haber said, the CARA law is relatively new. We've been working on it, on the upgrade, the CARA enhancement for at least that long. But other than that, that's the best answer I can give you with respect to a time frame.
How long does the CARA law allow for a company to upgrade, or does it give when that has to be put into place?
No, it does not, or it did not.
So there was no immediate effect, or
There was just a date when it went into effect, which I believe was the summer of last year.
Mr. Comfrey, do we know if this is occurring broadly on all prescriptions that were partially filled that were C2s, or is this were you able to isolate whether this is occurring all the time? I think Mr. Hyper brought up an excellent point that had this been occurring where there was refills for C2 prescriptions on labels, I would have thought we would have heard about this before, because I believe the CARE Act became effective late last year, I think, from memory. Don't hold me to it, but I do think that we probably would have heard about this since then. So what type of root cause analysis did you do? And have you been able to try and identify the types of prescriptions that might have been impacted by this?
We really haven't, unfortunately. As I said, it wasn't, I'm not going to say this one was an outlier, but it was small enough that, again, it ended up getting exacerbated by the Adderall shortage. So I unfortunately, I can't really, I did not get an answer as to how widespread this may have been. It is apparently small because, as you said, we haven't seen it before. We haven't had any board. I will tell you, we haven't had any board bring this complaint to us. This is the first time I've seen it.
Can we have a motion to letter of concern, but conditional, like within a month, they have to fix the issue, or 2 weeks, whatever board member thinks appropriate. And if it's not fixed, we bring him back for a further discussion of how we do that.
one of the issues that I think any large corporation, you not only have certain software, but you've got to change a lot of things in the interconnection with other software. It doesn't happen overnight.
Correct.
No matter what you're
Correct.
doing.
We have to recognize this.
It is not a
You have to
situation
remind
where
them.
we flip a switch and
Yeah.
say, oh, CARA's on.
And I'm sure,
It doesn't work, but at the same time, what you mentioned earlier, notifying the pharmacists that you have to deal with this, I think is important for them to know. They must know, so it can be dealt with more effectively. Or in fact, just dealt with.
And I'm not sure if you have pharmacists in the IT department, it's not our business there, but you know what I mean? So because obviously the urgency is not there, about fixing things, which.
I don't know that we can assume that,
yeah,
that the
yeah.
urgency is not there. I mean,
Okay.
IT changes when you're talking about a national corporation are very complicated.
Okay, yes.
I
agree.
would disagree that the urgency is not there.
Okay,
I
great. So you
respectfully will
yeah,
disagree with you.
okay. I'm glad it's there. So I have a motion. I don't know if you can do it both, we give conditional, we do a letter of concern in condition to fix the issue, or.
We can't mandate that. We don't
Okay.
control that. That's out of the board's
Okay.
realm of responsibility. We look at the conduct that occurred. It
Okay.
appears that there are representations that the CVS is undertaking, remediation and understands the urgency. But he said not only is there, IT involved, but then there, is rollout and training and changing documents. So
Okay.
we cannot dictate when the remedial action will be completed.
Okay, so my motion is the letter of concern to the permit. I maintain my motion.
Madam Chair, if I may
Yes.
ask Ms. Galvin a question, or Mr. Hargraves, is in that letter of concern, can we strongly suggest that they train their pharmacist on the requirements of this act? As that may be lacking.
That could be a suggestion.
So we can make motion letter of concern due to lack of training, staff training.
A letter of concern regarding this matter, but strongly suggesting that they train their staff regarding this act.
So I make this my motion.
I would want to include making sure their systems are compliant with federal law, which is where they're headed, but that would be part of the letter of concern, I believe.
I'm sure like there is village there, many people working on it and the big corporation, and I'm sure they want to
Just
be
document it
compliant.
in the
Yeah.
letter. We know that's where they're headed, that's where they've said, and I just would like to see that documented in the letter as well.
Yeah, if I add this to my motion.
I have a motion. Do I have a second?
I'll second.
A motion and a second. Any discussion?
So no discussion of any civil penalties.
That is not the motion on the floor.
I don't think the civil penalty will, they already got a message, you know what I mean? And this is my opinion. I mean, so, and I'm sure they're working on it. I'm sure, hopefully they will fix it soon.
But the thing is that they have gotten the message before. This is not something new. And I'm in favor of some sort of financial penalty, not a lot, just as a little financial disciplinary, just to let them know that the federal law was not followed. And then reminding them that they need to focus on coaching their staff and assuring us that their system moving forward will be in compliance with the federal law.
So we have a motion on the floor and a little bit of discussion. Dr. Gandhi, I think we should do a roll call because I don't know that we will have consensus.
I think so as well, Madam Chair.
To be clear, the motion on the floor is a letter of concern to the permit holder relating to the underlying allegations, suggesting that they train their staff on the requirements of CARA and to ensure that their updated IT system will be compliant with federal law. The motion does not include anything about a civil penalty.
Is that correct?
Correct.
Madam Chair, I have a question.
Yes.
What kind of penalty, civil penalty would you propose?
I'm thinking $1,000.
I think we need to vote on the motion that's on the floor and then we can move forward
Well,
from there.
Madam Chair, where I was going with that was the party that made the motion may or may not want to modify that motion before we vote on it, where that could be put together in one if we wanted to do that.
I don't think we can add civil penalty to a letter of concern.
No, that would be a consent
It does
agreement.
be consent agreement.
Wouldn't it?
So
Maybe.
Or we could do a non-disciplinary fine.
If the board seems it's more administrative, then we do have that carve out for the board to make that decision.
So I maintain my motion.
Did you say you maintain your motion? Yeah, okay.
I keep it.
Does the second remain?
Yes.
Okay, let's have the discussion on the motion. Dr. Gandhi, if you would like to do roll call.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Wamsley,
Aye.
Ms. Lehan's recused, Mr. Dang,
Nay.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Nay.
5 ayes, 2 nays, Madam Chair. Ayes have it.
Thank you, Dr. Gandhi. That concludes this matter. Next is 26H, complaint 23-0482. And I think Mr. Convery is remaining. Do we have any additional people joining you?
We do.
Very well. 26H. I like to keep everybody guessing, so I just move all over the place. Oh, wow, we've got a whole army here. All right, Mr. Convery, if you could introduce your guests.
I'll let them introduce themselves because I believe they were all invited here by the board.
Thank you.
I am here again, Brian Convery, CVS Health. I am here as a representative of CVS 9314.
Pharmacist in charge, Matthew Stump of this 9314 CVS.
Kristen Basha here on behalf of Argon Bejijan, a pharmacist.
Zainab Al-Sadi, pharmacy technician.
And if you could also introduce yourself, please come to the mic.
Argon Begijan, I was the pharmacist at the time.
Thank you.
And I apologize, Ms. Walmsley. Mr. Stump, the PIC was not noticed to be here. He is actually.
But he's here on
He
behalf
is
of the
here.
permit
He
with
is here
you,
on
with
behalf of the
yourself.
pharmacy permit, but he was not, I apologize. He was not individually noticed to be here.
Okay, well, welcome.
error.
Mr. Castaneda, if you could introduce yourself and please give a summary of the case.
Good morning, board members. Ben Castaneda, Compliance Officer, Board of Pharmacy. So complaint 230482 came about as a result of a complainant getting a 3-month supply in 3 separate bottles of 60 for a metformin prescription. And 2 of the bottles had her name on it. The third had somebody else's name. The complainant did not realize the second bottle, she had someone else's label on it because the first month she took had her name. Then she realized during the second month when she began the prescription that someone else's name was on that label. She also indicated in the complaint that the same incident happened with her husband prior. This complaint was 220461, which is referenced in the report. It should be, instead of 230461, it should be 220461. It was for the exact same medication, and that complaint was adjudicated by the board at its 2022 December meeting. The pharmacy records show that the 2 prescriptions were filled and labeled by the pharmacy technician on June 24th, 23. And they're filled within an hour of each other. During the investigation, the PISD stated that the prescription was filled by the Kirby Lester automated counting device. And that what happens is that it fills multiple prescriptions and they sit on a conveyor belt waiting to be picked by the technician for the final steps on filling that prescription. A review of the video surveillance was not very helpful. It could because the surveillance of the filling station was blocked by the counter. Couldn't really see what was going on. And also the complainant did send in pictures of the bottle labeled with somebody else's name, which are included in your board book.
Thank you, Mr. Castaneda. Mr. Convery, if you'd like to make a comment.
I would. Ms. Walmsley, this is hopefully the last time you'll be seeing me on the virtual verification issue, which the board is well aware I've been here numerous times on. The last time I was here on that was August, at which time I promised the board that we would roll out a second photograph. I will point out that the error that underlies this incident occurred in June, before we rolled out that second picture. So I am optimistic. To the extent I would say I'm positive that rolling out the second picture, which we have done, that was completed at some point in December, I believe, would have alleviated this issue. As a matter of fact, that's why I have my pharmacy manager sitting here to tell the board to confirm that we have rolled it out and his opinion as to whether that would have happened with the second picture, with the second photograph.
Thank you. Board members?
Can you explain the process of how this medication was filled? So there's a statement here kind of saying that there are multiple vials sitting on the machine and there was a backlog, and maybe that's how things got mixed up. Can you explain that process a little more?
It's a possibility, I suppose. One thing I would say, you said that it was filled and labeled by the technician. It's actually filled and labeled by the Kirby. The robot labels it as well. Yeah, if another thing we've implemented is not printing so far ahead or putting things through where we get a backlog. So many prescriptions aren't available to be possibly misfiled or put in a missed bag. But just like they come out, this was a 90-day supply. So in 3 bottles of 60, each bottle will say 60 out of 180 with the patient's name. They, supposed to scan the bottles. We have the second picture in place now. Before we took pictures of the tablets after we scan the bottles. Now we take pictures of the tablets and then the bottles after with the pills on them, turned to where you can see the prescription number and the quantity, and then that goes to the pharmacist verification.
So in the case of a prescription like this, where there was 3 different bottles, what would those pictures look like? So you'd have a picture of the tablets, and then would you have a picture of each of the vials?
Process is that we are supposed to have one picture with all 3 vials, assuming that they fit.
Okay.
In the view of the camera.
In the event that they did not fit?
There would be multiple pictures.
Or we can also toggle to have a bigger picture.
Okay.
Outside of the containment box that we
Okay.
usually take the picture in.
So the machine was working properly. It was the wrong prescription was just grabbed from the machine and placed and bagged incorrectly. Is that in summary?
Yes, it was it's like what I'd probably assume what happened was a batch fill. So it will fill we're a very busy store, so it'd fill the metformin 1000s and then all at once gets them going. But it was processed properly and just moved, and maybe if there's too many bottles, they got situated where they weren't together by themselves or for that patient, and it must have been just grabbed the wrong bottle.
Mr. Castaneda mentioned that this was not the second time this happened to this family, and just curious what changes you did locally there at the store to prevent this from happening again. But were there any process improvement changes between December of 22 and now?
I came along in June of this last year, but it's been changes going along where we make sure that each prescription is separated with itself, not combined with other prescriptions, even by even in the same family, like one prescription in one bag kind of thing. And then also the second picture was implemented, and now we have our printing process. Usually we'll only have one person print the labels, where 10 or 20 at a time. And then that way we're only filling, a small amount where we won't have a backlog of prescriptions or have to go and find a prescription after it's been printed.
I have a question for the pharmacist that filled the prescription.
Yes.
What did you learn from this, and what did you do to change the process?
Sure. So at the time, CVS had a virtual verification process of the policy was for the technician to take a picture of the actual pills that's in the vials and also scan the labels into the system. And as a pharmacist, we were required to look at the image that the technician took to make sure it's the correct medication and to check and see if the actual label was scanned into the system, which was already done in this case. As a result, once I was notified about the issue, I had the technician do additional CEs as far as for HIPAA and also for medication errors. I also had her do additional training with CVS and also trained her myself, retrained her in the process. In addition, I did additional CEs, and this week, back then, and also this week, I did an additional 10 hours of CEs, and she did a additional, I believe, 5 or so CEs. And also afterwards, I required all the technicians to take actual pictures of the vials for all medications, not just medication that was coming out of the robot, but all the medications across the board, to make sure the labels is actually displayed in the image, so I can verify it myself to make sure the right medication is for the right patient with the right pills inside of it. And then later on in December, CVS rolled out the policy across all the stores in Arizona.
Thank you.
But I did that beforehand. So.
Okay, thank you. Appreciate
Also-
that.
And also, if I may, Mr. Anderson, one additional update that we did enhancement, not just at this store, but as this process continues, we're obviously constantly looking to update and improve on it. One of the enhancements that we have done is that on this situation where this is 3 different vials, each of the vials has a different barcode. So the system will read that each of the vials has to be separately scanned. And if a tech, a pharmacist, whoever's doing production, takes the same vial and scans it 3 times, the system will block that. So the system will read that the 3 separate barcodes. So it will read that there are 3 separate barcodes here, but that 3 separate barcodes in this situation weren't going to match up with that same patient.
I really like that improvement. That's good.
Thank you for that addition.
Board members, if I may, real quick.
Yes.
When I did the investigation at the site, the PIC did tell me that his technicians were directed previously to take pictures of each bottle during the visual verification. And I'm not sure where that fell in time and like in terms of timing with the rollout of their improvements of their system.
Thank you. Additional questions? Discussion?
We have a comment, if that's okay.
Yes, please.
Yeah, so at the time, it wasn't CVS policy, and no one really discussed as far as taking images of the actual vials. That was implemented after. Just want to make that clear. Thank you.
Thank you.
And I would like to say, based on the foregoing, we are requesting that the complaint be dismissed against the pharmacist. Okay.
Board members?
I was going to suggest continuing education and error prevention. And it seems like the pharmacist and the technician have already completed those. So I suppose we could, require them and say that the ones that they've already done meet the requirements if we want, or don't know if you guys have any other thoughts.
I would agree with that for the pharmacist and the technician. So 3 hours in continuing education for continuous quality improvement. And if they meet the staff's approval, that those could be counted towards that.
The only thing I was thinking was the pharmacist really didn't play a role except in his supervisory role. He didn't play a role in the actual process.
It's a fair point.
I would-
Who bags it though? Is
The tech.
the technician is bagging and labeling for pickup?
Which is why rewind from the prior cases that we asked for that picture to be there.
I would be in favor of dismissing it for the pharmacist.
In the continuing education CE for the technician?
Yes.
Second.
Can we do those in separate motions?
All right, so let's take the.
I just have one question.
No,
Also,
okay, go
the
ahead.
The permit holder, we're gonna keep it in the complaint or just dismiss? the
I think
permit
we'll
holder?
handle all 3 separately.
Okay.
So let's start with the pharmacist.
Okay,
That's
I'll make
easy.
a motion to dismiss the complaint against the pharmacist.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. With regards to the technician,
I would make a motion for 3 hours of non-disciplinary CE, accepting the CE that's already been completed,
if deemed appropriate by staff.
if deemed appropriate by the staff.
So in what area are you looking?
Med air prevention, and I believe they mentioned that it was about HIPAA, and that would be acceptable as well.
So sorry, can I make a comment? I already did 7 hours of CEs.
You would just need to provide that to the board.
That's what our motion is for you to provide that potentially.
Okay.
This would be in addition to what you're already required to do for your renewal.
Okay, so I had a motion. Do I have a second? A motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. With regards to the permit holder.
I make motion to dismiss permit holder from the case.
I was leaning more towards a letter of concern. I know that they have process improvements in place. We've been assured it multiple times. We've now been told it is in place. And I'm quite impressed with what's been put in place. I love the idea about the scanning. And the second picture is what we were really hoping to see. And they have done that. But I do think it's worth documenting that at the time, this is not what was in place.
I agree with the letter of concern to memorialize it.
I'll make that my motion, a letter of concern to the permit holder.
Second.
I have a motion and a second. Any discussion? I'm gonna throw one out there just to be contrary, because I feel like I should. This did occur before we even had that last conference where they agreed to do that. I feel like we're kind of relitigating something that we've already asked in the past. I agree, it was a concern. It's been corrected. They've actually taken additional steps above and beyond what we even asked them to. So I don't know that I think we need to do anything additional with our permit holder, although it is non-disciplinary, so I could be swayed otherwise. But I just wanted to throw that out there as an alternative.
I prefer the alternative myself.
Dismiss.
Yes.
So we have a motion and a second on the floor. I guess let's vote the motion, and then if we don't have consensus, we can re-go it unless somebody wants to withdraw a motion.
I'm comfortable with keeping the documentation.
With the letter of
so-
concern.
Letter of concern.
Second still stands?
Yes.
Okay. Dr. Gandhi, do roll call, please.
Can you repeat what motion we're voting on right now?
A letter of concern to the permit holder?
Mr. Thorwald,
Nay.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Nay.
Ms. Lehan is recused, Mr. Dang,
Aye.
Mr. Al Nassif,
Nay.
Mr. Anderson.
Aye.
Ayes have it 4-3, Madam Chair.
All right, that concludes this matter. Thank you for being here. Let's see. Let's try and knock off maybe a couple more things before lunch. I know we've got some people that need to leave a little bit early. So, let's go to special requests. Is that correct? Is that what's up next,
That is
Jennifer?
correct, Madam Chair, and there are some items that may not require a lot of discussion.
Okay.
32E and possibly 32F.
All right, well, let's jump to 32E then. This is discussion, consideration, and possible action regarding request made by On the Go Pharmacy to extend their deviation that was previously approved by the board. Is On the Go Pharmacy available?
Hi, good morning. Chris Robinson, Pickett, On the Go Pharmacy.
Hello, Mr. Robinson. If you could please tell us about your request today.
We're just requesting to renew the deviation request that was last discussed at the 2022 meeting to continue to do business at our current location.
I have one question for the compliance officer. I'm not sure which compliance officer has this pharmacy.
It was RAM.
Oh, Ram, you're finally on the hot seat. I've been waiting for this. We've only have one other new compliance officer that hasn't been up here yet. So, all right.
Good morning, board members. This is Ram Kalapuri, Compliance Officer.
Hello. My question for you is, have you been out to the pharmacy to inspect them since the deviation request?
Not prior to the deviation request, I was in the pharmacy to inspect. That was on December 1st. And at the time, I was looking at the permits and I noticed that this is going to expire, the deviation request. So I told them, that they need to act on it. So that,
Did you have any concerns with the space deviation that we've granted? Do you feel like it's safe based on what you were able to see on your visit?
yes.
Okay, that answers my question.
I feel comfortable with approving this request.
And this would be for 2 years? Is that what the request is for a 2-year deviation?
Typically it is, but if it's on size, I'm not sure if we should limit it unless the business model changes.
Okay, I'm comfortable with that.
So do I need to memorialize that? in my
I see
motion?
Jennifer moving.
The board also requested a deviation with the original approval of the deviation. It had to do with how many individuals could be in the pharmacy. I'm not sure if that's something that the board wants to readdress. And that's in your book as well.
At that time, I was in the pharmacy for inspection. There is only one employee, that's the pharmacist in charge, Chris Robinson. So nobody was there.
Mr. Robinson, do you need the personnel deviation still or just the space?
I'm the only employee, so either way, it doesn't affect.
Okay, so
I mean, our business model, I don't anticipate, and like when I signed the statement 2 years ago, if that ever changed, I let you guys know, but we have no plans to expand. It's just me, and it has been me for this whole time.
I'd be comfortable with keeping that piece in place, that if there were a change that we'd be notified.
is that your motion?
That's my motion.
I second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none, thank you. Thank you, Mr. Robinson. See, Ram, we weren't so mean to you.
Thank you. Have a great day.
All right, 32F, you said, Dr. Gandhi's next.
Yes, Madam Chair.
All right, 32F, discussion, consideration, and possible action regarding the request made by Saliba's Extended Care Pharmacy Tucson and Saliba's Extended Care Pharmacy to deviate from R423701.
Guys, you can expand to the other table if you'd like. So it's a little easier.
Welcome, Mr. Morris and friends. If you could please introduce yourselves for the record and
Right.
tell us why you're here today.
Roger Morris, counsel for Saliba's. John?
I'm John Saliba, president.
Michael Veltri, compliance pharmacist with Saliba's Pharmacy.
I'm Richard England. I'm the pharmacist in charge, Saliba's Pharmacy. We're here for a request for a deviation. We have outlined it in the letter, but there is a provision for long-term care pharmacies that have emergency kits. And you can see the old-fashioned emergency kit that they're going to talk about in a second to be able to do it, that requires a pharmacist to go out and restock the emergency kit. Technically, an intern can do it, but they have to be physically accompanied by a pharmacist. So a pharmacist still has to go to do it. For a lot of reasons with regard to technology, for some of the updates that are going on here, we don't think it necessary for a pharmacist to do it anymore. We would like to be able to ship it with a driver to be able to ship the drugs out for the emergency kits, because once they're there, the staff has access to the drugs anyway. It's the question if they put it in. With that, I have them give you a little explanation. John's going to talk about the pharmacy. Then we're going to talk about what's going on today and what this little modification would do. John?
John, can you push the bar?
There you go.
Thank you.
Oh, thanks. Just a little bit of an overview. Saliba's Extended Care Pharmacy we founded back in 1999 to service long-term care facilities across the state. Currently, we have pharmacy in Tucson and in Phoenix, and service all areas of Arizona. And although the majority of our business is serving assisted living facilities, what we're talking about today is skilled nursing facilities. And in skilled nursing facilities, they're allowed to have an emergency kit. And traditionally, pharmacies have used the very low-tech version of the emergency kit. We deploy mostly electronic emergency dispensing machines, and currently, whereas it's not required that a pharmacist deliver that box, it's required that a pharmacist go out to stock the electronic machines, and we would like to see a better use of pharmacist time.
With that, Rick, you want to talk about the current process?
Sure. So we do have some that still utilize the tackle box process as well. And in that process, the pharmacist or no, as the pharmacy approves it, the delivery driver takes the box to the facility. They bring it to the nurse's station, the nurse signs for it, and then they put that in the locked med room. And then that box just stays in there like that. At that time, then if the nurse has to access it at any point, they have to call the pharmacy, verify we have the prescription. They would pop off the lock. And now they have access to every drug that's in this kit at that moment. They tell us what they're taking. We take it, they fill out a form. They pull out the yellow one, and that tells us when this comes back to us that this has been accessed by the facility. If for some reason they don't call us when they do this and it comes back with a yellow one, we know they accessed it and we know we weren't informed. What we do with the electronic ones is I go out to the machines and the meds are packaged in either tamper evident packaging or a cube system. And in the machine, you have to log in and then the drawer pops open and you put the medication in and then you close the drawer and all the medications are secured at that moment until someone else logs into the machine and accesses that drug. And they only have access to the drugs available at that time. They don't have access to every drug available in the machine. All controlled drugs are separated, require a witness from that machine. The reporting is in real time. So we can see anytime anything's added to the machine, taken from the machine, orders canceled, low inventory. And the problem is just as a recent example was in Flagstaff, where we service 2 skilled nursing facilities, one with a high acuity, the snowstorm came. And we couldn't get our delivery up there for 2 days and they relied on the machine the whole time. Well, if they empty that out, I go on Friday, I go again on Monday. And it's just really hard to schedule having a pharmacist drive to do this in the higher technology piece versus the low tech piece. So Mike will explain what our suggestion of the process change is.
So what we're specifically asking for is just to change the step of loading the machine. So as my colleagues have already stated, the current process for loading these machines, it's a pharmacist doing it. Only a pharmacist can do it based on the way that the rules and regulations are currently written. What we hope to do is to deliver a tamper evident tackle box, kind of like this one, that is locked and serial numbered, and it has the medications in it that are either labeled, prepackaged, tamper evident, or they'll be in this cube system. And it'll be signed. Delivery will be signed for by a nurse, and the nurse will take custody of the medication, and a designated staff member at the facility will then load the machine. It's essentially just an extension of the current process using this tackle box, but we're just taking it a step forward to make it a little bit more safe for the facilities. By doing this, we'll have better tracking, and we'll also have those real-time reports that we can pull. So at any time I can log into a portal online and see anything that's happening with this machine. I can't do that with a tackle box. It's also going to enhance the security and decrease the risk of things like diversion. So every single controlled substance that's in one of these machines is either it's in its own drawer or it's in its own cube. And in order to access that drawer or the cube, it needs to be authorized for dispensing at pharmacy level. So we have various reports that we can pull at any given time. One specifically, we can pull a report to see when the medication was delivered and when it was taken from the tackle box and loaded right into the machine. One of the most critical times for a patient is the transition of care when they're leaving a hospital and they're either going back home, or in this case, they're going to a skilled nursing facility. And most of the patients that we service in these skilled nursing facilities are coming directly from a hospital. There's medications that they need pretty much the second they get back to the facility. And if they don't have access to them, they're risking decompensation, and they can be going directly back to the hospital instead of at a rehab center where they're supposed to be getting better. By allowing someone other than a pharmacist to load these machines, we're going to increase the accessibility and availability of these meds to these patients and the nursing staff. And hopefully take that pharmacist who would, like Rick in this case, who's going to be going to a facility to load this machine. He could stay back at the pharmacy and be doing clinical work that he's trained to do as a pharmacist which in turn will enhance patient care and better outcomes for our patients. And we're happy to take any questions you guys might have.
And again, everything that they described to you, they're already doing is compliant with the law. The only difference is whether it's Rick delivering the drugs to the machine or they send it up with a courier from them and have one of the nursing staff put it in the machine. And that nursing staff immediately has access to it, even if Rick puts it in, to get the drugs out when they need it. It's the same staff.
So my question, I have one question. Is it like a closed loop system? So once you validate whatever is in the cube or what have you and put it in there until it matches the machine, there's no way that it can be accessed?
No, that's not true. I mean, anybody with diversion in mind they can get into these things. I mean, they really could. What we're really trying to minimize is transferring more from the box away, because right now they have that complete access. They always have that access. And doing it this way would allow them they would only have access to these meds in that one period of time when the driver hands it to the nurse and she moves from that point to the machine and then enters them in. In this case, with the box, what they do is the driver hands it to the nurse, she sets it in the med room, and everybody has access to every drug in that box in the point. So in this case, this would be the only opportunity would be between here and there, but we would be able to identify that quickly because we know we just delivered it. We would see it either entered or not entered at that moment. And then running our reports and the real-time data would really be able to enhance that.
This is an improvement on the existing system. It is not a perfect system, but that's the necessary because of the emergency nature of these drugs.
That makes sense to me. Thank you.
So the RN, the LPN, whoever's going to be potentially restocking this automated dispensing machine, is there a barcode that they're going to scan the tablet and also the machine QB, and there's going to be that link? How does that work?
Correct. And it's a supervisor level only that can enter meds into the machine. So you're talking charge nurse or the ADON, DON type of thing. With this, just an additional piece to that, this allows us to schedule it and have it there when those nurses are available as well. But yes, in the QB, it's a scan, but there's a PIN number as well that verifies that drug is the correct drug that comes from the pharmacy. On the label, it has the drug name, it has the location code of where in the machine it goes, and then the PIN number. And it will confirm the quantity, the PIN number that you have the correct drug, and the location that you put it in.
I feel okay, so to move to approve the deviation. So that's my motion.
I'll second.
A motion and a second. Any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries.
Thank you.
Thank you. All right, let's just recess for lunch then. We'll come back at 1 o'clock. Don't get used to it. All right, welcome back. We will resume the meeting from lunch. Dr. Gandhi, if you could take a roll call, please.
Certainly, Madam Chair. Mr. Thorwald,
Here.
Ms. Nair,
Here.
Ms. Davis,
Present.
Ms. Walmsley,
Here.
Ms. Lehan,
Present.
Mr. Dang, Mr. Al Nassif.
Here.
And Mr. Anderson.
Here.
All accounted for, Madam Chair.
Thank you, Dr. Gandhi. And quick reminder, if you want your CE, please make sure that you sign in on the table in the back so that you can get your CE certificate for the afternoon. 32B, is that the right place to go?
That is, Madam Chair, yes.
All right, thank you. Thentia, this is a status on new licensing system and inspection database. Dr. Gandhi, do you want to go ahead and introduce this one? I know you've been working very closely with them.
Certainly, Madam Chair. So we currently have an active database today, and our hopes was to move to a more enhanced database to provide more data, more tracking points, providing an inspection, a report. Our current database doesn't have a functioning inspection process. It's more manual driven. And so our hope was to move to something more robust. And we're always looking to look for a better mousetrap, and this we thought was going to be the way to do it. Sean, are you online? If you can mute yourself and jump in after I conclude my little summary, that'd be great.
Okay.
We signed a contract in November of 2022, and we are right now in February of 2024. Intentia is here to talk about not only their database, but their timeline. And I think Ms. Walmsley, you and I have talked about some of the pain points we've had in the process of migrating our database from one to the other. So with that, I can fill in the gaps during the conversation with Tentia, if that's okay, Madam Chair.
Yes, please.
Ms. Cole, are you available?
Yes.
All right.
Can everybody hear me okay?
Yep.
Okay, perfect. My name is Shauna Cole. I am the VP of Delivery with Thentia. I also have Natasha, our Chief of Staff, on as well. And so, Natasha, would you like to introduce yourself?
Hi there. Yes, good afternoon. My name's Natasha Giuffre. I'm Chief of Staff for Thentia. I'm also legal counsel for Thentia, but I'm not here in that capacity today. Just to give you a little bit of background of who I am, I have experience working at a regulator in Ontario, both in licensing and in prosecutions and discipline. And I come to Thentia with that subject matter expertise and have now moved into the Chief of Staff role. And thank you very much for permitting me to attend your meeting today.
Thank you, Natasha. Again, Shauna Cole. So I have been with Thentia now for a couple years, and I actually came from the state of Oklahoma, where I was charged with managing the relationship between the state of Oklahoma and Thentia. So I've had an experience on both sides of the program thus far. And so I believe what we want to talk about today is kind of where we started, where we are at, and where we're going. So I'm going to ask Natasha to talk a little bit about the timeline up to this point, and I'm going to talk about where we're going. And so if you don't mind, this is kind of going to be a team effort as we move forward.
Yeah, very well. And so, just briefly, I think I would just really like to, cut to the chase, as it were, and just say that, our position is that this, the timeline and the delivery process, the way it's occurred, has not been smooth, and it has not gone as we expected or as we projected. And we're definitely internally, not content with that. There are some things that should have been done better on our end, and we take ownership for that. And, obviously we apologize for that. However, this is a partnership, and we want to be a good partner, and we want to ensure that, we're bringing your organization what it needs in order to do its very important work well. And to that end, we have internally, reviewed and have put together a plan so that we can ensure that we get you what you need, quite frankly, and that you're successful, and that the Thentia Cloud solution works for you. The timeline, and Shauna will take you through that. The timeline that she has put together with the rest of the team is one that we are very, confident with. It is one that, leaves us room to account for any kind of delay or incident or absence on in terms of both parties. We wanted to make sure that there was cushion so that we were producing for you, and that there was going to be, no delay or extension, and that we get you where you need to be by the end of June. And so with that, Shauna, I think it would be great if you could walk us through what our plan is so that, we can deliver on what this organization needs.
Okay, thank you. I will do that. So unfortunately, it doesn't look like I have the ability to share my screen, so I'm going to walk through it. I will be happy to send this out to any participants after, so that you have a copy of what we'll be going through today. So as part of the move forward process, so what we're looking at is right now, we're in configurations and also quality assurance testing. And so those things are happening in tandem with each other. We are working on the completion of the application module, the licensee module, the business module, inspections, complaints, public register, and then also the workbench as part of this project. And so right now we are working through each one of those modules for configurations. We're looking to have configurations complete and ready to complete, and then going into about another week of business validation by mid-April. And so that will allow the board to then continue business validation through the end of April. And once business validation is done, and let me just explain a little bit about what that does mean, is business validation allows for the board to go in and make sure that the configurations that we've built out have been completed as part of the requirements that they did explain to us as part of the planning and requirement sessions that we've hosted many of sessions with the board. And so that will allow the board to then go in, make sure that everything looks adequate to them and they are happy with the build that we did. We're working very closely with the board at this time. I've talked with Kim this morning, and we're going to add some additional meetings so that we can work those business validation sessions side by side a little bit more often than what we have up to this point. Once the business validation is complete, we do want to have our quality assurance team go through and complete their review of an end-to-end test. They have been doing testing up to this point and will continue to do testing during the configuration build, but they are going to also want to do end-to-end testing to make sure everything that we've put in place does work for the board ahead of us going to a testing opportunity for the board to walk through end-to-end testing as well. And so that's going to be done in tandem with the business validation. As soon as quality assurance has then approved it, what we would do is we actually have a committee that we have in place where everything goes through before it comes over to the board for user acceptance testing. And this is called our Quality Control Committee. It is a group of leadership individuals at Thentia that does a review of the entire build of the solution, reviewing the statement of work, the solutions package, and the requirements that were signed off on. Also looking at the quality assurance testing that was completed, the training plan that was provided to the board. And we walk through each piece of the portal build and then also the workbench to ensure that before it goes to user acceptance testing, that it is quality, it has been approved for quality review. And so that takes about a week to a week and a half for that to happen. And that will be right before quality assurance. I apologize, right before user acceptance testing is asked to start. So what we'll be looking at doing user acceptance testing will be in the month of May. There's about a 2-week user acceptance testing window that we're going to be asking for. And so we will be working around the board schedules, because I know that during the time that we are working with the board, there are some blackout periods that they have requested of us so that they can prepare for the board meetings. And so we have taken that into account as we're building out these plans. Once the user acceptance testing is complete, we would ask that the board sign off on user acceptance testing before we go into our launch cycle. And so launch allows us then to push all of the configurations that we have completed into our production environment. And then we're also going to load the data into our production environment as well. It is my understanding that the current vendor does require a 3-week lead time for accessing the production data. And so we would be working closely with the board to get with the vendor ahead of that time so that they know when we'll need to expect that production data to be provided to us. The launch window that we're looking at will start in late May and go through in our middle of June. What we'll be looking at doing during that time is we'll, as I mentioned, push all of the production configurations, and we'll also load the final data. We're going to then have our quality assurance team go in and do a quality review in production to make sure the configurations came over properly. And then also they do a data validation in production as well. They're going to penny test to make sure that your payment processor is set up as well. And then we're going to ask the board to do what we would call a soft launch. A soft launch is allowing a group of individuals, and we'll work with the board to identify who those individuals are, to actually go into the production environment and test to make sure that there aren't any issues that would be identified before we would go to a full launch. So we'll be looking to do that about middle of June. We'll also be doing some production data validation during that time with the board's assistance and working closely with them to alleviate any data issues that might come up. Based on that soft launch, we would be looking at doing a full launch into the production environment, meaning that you're going to post your links out to the public by June 30th. And so that is the timeline that we're proposing as part of our presentation today. I'd be glad to answer any questions that might be asked.
I have a couple. Thank you for that presentation. So you mentioned that the launch has not gone as expected. If I recall, we've been working on this process for a little while. When did you expect, or when was our contract that work was supposed to be done versus when it's being completed?
So the original statement of work allowed for a 32 week build time. And I apologize, my jaw is acting up. A 32-week build time. The contract was signed in late 22, and the expectation was that we would have an original launch date of, as I mentioned, 32 weeks into the year. We did a change request in late June of last year. I apologize, in April of last year, that changed that launch window to end of June of last year. After going into those conversations with the board, we did understand that a lot of the planning and requirements that were understood at the time did not fully capture everything that needed to be a part of the project. So we did need to take a step back and complete those planning and requirement sessions, and we have been doing that up to this point. We are still in the process of doing that for the inspections portal, allowing for some new forms that the board has is asking to be made available to be included in this and in the build as well. And so we are still in tandem with the configurations, doing planning and requirements for the inspections portal. So to answer your question, we had 2 launches that we had originally done. The original one was the first part of 23. The second part was late September. It was late summer of 23. And now we're proposing that we would go live in June of 24.
So a year late.
Yes.
from a contracting standpoint, that concerns me, Cam. I'm glad we have another system to fall back on, that we are still able to use, because had we depended on this, we would not be able to process licenses or any of those other kinds of things. So it is concerning to me. I don't know what your goal is to get out of the meeting today, but it's definitely concerning to me. And if this continues to get pushed out, I'm assume we're paying for this work as well.
Well, that was the change order. Initially, it was set out to pay quarterly as the project was being built, but then the change order changed that because it was, I think the project was underestimated. We were categorized, and Tentia groups it as a small, medium, and large shirt. I think T-shirt. Am I correct, Jen? And we
That
were
is
grouped.
That's a good IT term.
And I think we were categorized in the small, and correct me if I'm wrong, Shauna, but we were initially slated in a small T-shirt size. And they soon learned that it was more complex than a small T-shirt.
That is true.
Which now has put us a year out from where we are. But no, we are not paying quarterly. The change order stopped us from paying until the project is complete. But there is a funding issue that just came to light, which is, I think the last report I had, Shauna, was the go live date was sometime in July, end of July. I think on my birthday. It would have been a good birthday present. But it would have fallen outside of the fiscal calendar year. And our funding issue doesn't carry over to the new fiscal calendar year.
Yeah, after a conversation with ADOA yesterday, I did raise that concern to our leadership, and we have adjusted the project plan to accommodate for that so that it does complete within this fiscal year.
I can share with you that options were discussed with ADOA about what are our options regarding this contract, and are there any other options? Right now, Tentia is the only option because I think it had to go through quite a bit of vetting process. ADOA procurement actually has a strict guideline on how we can go to we can go to partnership with. It's very limited in our options. Right now, Tentia is the only option if we ever want to migrate from one database to another.
So it sounds like there isn't an option to cancel the contract or anything like that, even though they've not fulfilled their end of the bargain. But it does concern me. So if they continue to deliver late, then what happens? So if we don't have funding moving into the next fiscal year,
that becomes an issue.
Where does that leave us?
That's correct. And the option of reviewing the contract periodically does come up in our office and with ADOA procurement to see whether we really want to jump from one frying pan to another. Is the best option to stay with iGov, or is it the best option to continue? So we do constantly have discussions internally, all cards on the table regarding that matter. And we probably will continue to have those discussions. If we do decide that, we'd obviously need the support of ADOA procurement because they have an overarching contract as well. We have a subcontract with our agency, so we'll have to revisit all that stuff. It's not that we're not doing it. We do entertain that time to time. So the purpose of this is kind of like to give you guys an update on where we are on this project, what our hopes was to gain from having a new database, but also to show the board that, there are pain points. I do work for the board, and you guys need to know where we stand as far as our projects, and there's an accountability portion of my responsibility to you. So I wanted to draw that to your attention.
And so we'll just expect to have updates from you as things go by?
I think it's the right thing, because I know we not only is the accountability to you guys from me, but we also have the Auditor General that also is expecting a new database that is in compliance with state rules and regulations about checklists, about time, how much time we spend on applications and so forth. There are guidelines and statutes that we need to comply with. Our current database is not 100% compliant with those. So we have manual processes that we have put in place to keep us in compliance, but it's like a Band-Aid.
But that's taking extra time away from your staff from
Absolutely.
doing other things.
That's correct.
So, I mean, we're kind of stuck by the state procurement process. I think in private business, we would be out searching for new vendors if we had the opportunity to do that. But it sounds like our hands are tied at this point.
It may be, yeah. And again, I will keep you in the loop as to our progress in this venture of ours, and we'll continue to evaluate our options.
Just a quick note, the Oil and Gas Commission, obviously, were far different needs in some respects than the Pharmacy Board, but we're engaged in the same process right now and have been since last year. And this particular process is also used in other areas besides oil and gas. And it's in 25 states. The same company has been around. It's for that time, it's a nonprofit that is approved by ADOA.
So no further action is needed today.
Not at this time. I just wanted to draw it to your attention.
Any other questions or discussions from board members? Thank you for being present today. We appreciate it. Look forward to the next update.
Thank you.
32C, discussion, consideration, and possible action regarding Christopher Sean Stoffel's request to reconsider the board's decision to require him to pass the NEPLEX in order to proceed with reinstatement of his license. Is Mr. Stoffel present?
Madam Chair, I'm recused.
Thank you. Dr. Gandhi, do we see Mr. Stoffel online?
I see a Chris PIC OTG, but I don't know if that's Mr. Stoffel. But that's the only person I see with a similar first name.
Mr. Stoffel, if you're present, if you could please unmute and introduce yourself. Board members.
Madam Chair, I can share with you that when we had Mr. Stoffel at the last agenda, he had inquired afterwards that he didn't realize he had to appear. So I'm assuming that we may get a similar response after this meeting as well.
I really don't feel like we have much different information here. This is the second time we've placed this on the agenda. If it was important to him that we reconsider it, I would expect that he would be present. We've already given him 2 opportunities at this point.
I agree. So I make a motion to deny the request.
Second. Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. 32G, discussion, consideration, and possible action with regarding Kenneth Akawubi's
Madam
request.
Chair, Madam Chair,
Yeah.
I'm sorry, would we be able to go in order with 32D?
Oh, did I forget that one? Oh, I'm sorry. Hang tight there. I'm sorry.
Thank you.
32D, I got ahead of myself. Discussion, consideration, and possible action regarding the deviation request from Chewy. Thank you, Ms. Cannavon. Hello, gentlemen. If you could please introduce yourself.
Roger Morris, Quarles and Brady for Counsel for Chewy.
Rich Solinsky, Senior Pharmacy Compliance Manager for Chewy location in Goodyear, Arizona.
Welcome. It's good to see you on the other side of the table, Mr. Solinsky.
Thanks.
For those of you that don't know, Mr. Solinsky used to be a compliance officer for this board.
Yes, I had the pleasure of being a compliance officer for 10 years with the board. Back in 2003 through 2013 under L1.
Good to see you. Mr. Morris, if you want to proceed with your request.
Sure. This one is styled as a deviation variance, and it might end up being that way. I wanted to explain to you what Chewy wants to do. Whether it requires a variance or not will be up to you guys, or if the law's interpretation does not need that. Going back to 2015, a similar company to Chewy called VetSource started a concept where veterinarians would buy the prescription drugs, but they would have the prescription drugs delivered to VetSource's pharmacy, and VetSource would dispense the drugs on behalf of the veterinarians. VetSource was paid a dispensing fee for doing this. The veterinarian was the biller and collector of the bills and worked through it for his own patients to be able to do the prescriptions. As you know, in most states, including Arizona, veterinarians are allowed to sell prescription drugs to their own patients, the animals and the pet owners that they sell, to be able to deal with it. VetSource set up this model in Nevada earlier than 2015, but the relevant time is 2015, to be able to do this. And the Nevada board was unhappy with them, thought that was circumventing certain pharmacy laws, and brought a claim against VetSource. It went to litigation. It was ultimately resolved, and Nevada changed its law to allow VetSource to continue to do this. During that litigation, it came out that VetSource was doing this in a number of states, in fact, 10 different states: California, Colorado, Michigan, Minnesota, Pennsylvania, Oregon, Texas, Virginia, and Wisconsin. And all of them allowed the VetSource to do that. Since that time, a number of pharmacies and wholesalers have engaged in similar conduct, where a wholesale facility sells the drugs to the veterinarian, but the drugs are delivered to a pharmacy of the veterinarian's choice, and the veterinarian uses the pharmacy to dispense the drugs to the patient. The obvious benefit is pharmacists are frankly much better at storing drugs, managing drugs, counseling about the drugs than the veterinarians are, and getting the drugs out of the veterinarian's hands and into the pharmacy makes sense to do this. This model, in case you guys are jumping 6 steps ahead, and I'm sure you guys are because you're bright with that, does not work for humans. There are a number of federal and state laws that prohibit it, but it was VetSource's belief then, and a number of other veterinarian-focused pharmacies, sources today that believe this model is allowed to be able to do this one. Chewy started this model in Arizona a couple of years ago. They were inspected in March of 2023, and the inspector at that time identified this as a concern and specifically identified an Arizona rule, statute 32-1983C. This is all in your materials, but it says a full-service wholesale permittee must deliver prescription-only drugs only to the address listed on the license or permit. And the concern was that the wholesale facility that Chewy was selling from was not delivering it to the veterinarian's address, but was delivering it to the pharmacy's address. And the concern was that 32-1833C was in violation. However, if you look at the legislative history of 32-1983C, going back to 2005 when it was there, the legislature in Arizona actually had a preamble to the legislation explaining what the purpose of that rule was, to make you deliver only to the licensed address. And it's, again, in your written materials, but the critical purpose is, if drugs do not follow the normal channel, it can be difficult to determine the authenticity of the drugs being distributed and whether those drugs are counterfeit. That concern does not exist in this scenario. Chewy Wholesale is delivering directly to Chewy Retail, and there's no question about authenticity or counterfeit. More relevant to you, there are 3 states, the states of California, Texas, and Wisconsin, that have virtually identical language to 32-1983C, and they allow this model to occur. So we are here to request that either the interpretation of 32-1983C allows the delivery of the prescription drugs sold to the veterinarian to be delivered to the Chewy retail pharmacy, which is consistent with the statute. And if you guys agree with that, there's no reason for a deviation or variance. If you don't agree with that, then the request for the deviation and variance is, we frankly want to modernize this practice where the vets are dispensing the drugs to the animal owners. And frankly, the more prescriptions that we can have pharmacists and pharmacies dispensing, the better off the safety of everybody is. Pharmacists are by far the better experts than the veterinarians in the storage, use, and carrying of that drug. So we think this modernizes it and would allow for the variance. There was also a note in the inspector's comments in March that perhaps this was a shared service between the veterinarian and the pharmacy, and that we don't recognize shared services cross-discipline. That would be interesting at some point, but all of the pharmacy services that are being done by the Chewy pharmacy. We don't believe there's actually a shared service going on here. It is true that the veterinarian owns the drugs and the veterinarian is the recipient of the economics of it. Chewy is simply paid a dispensing fee and other ancillary fees for their services, but we think that works. So that is the information in front of you. Just so you know, in March, because this was raised by the inspector, Chewy discontinued this program in Arizona until we could get this resolved. Chewy submitted all kinds of information to the board in response to the write-up in their inspection. There was not a response, and we didn't expect there to be one. It was identified as a concern. They stopped doing it, but Chewy would like to go forward. There are a number of patients who have requested it from them, a number of veterinarians who would like to be in this, and frankly, they just think it's safer and better for the people who are the recipients of the drugs. So that's the information in front of you.
Thank you, Mr. Morse. Board members, questions, discussion?
I have a question. Why is the vet in this process at all?
The
I
vet
feel like
doesn't
they
have,
taken
sure,
out.
the vet doesn't have to be in the process. The vet can certainly buy the prescription drugs themselves, either directly from the manufacturer or from the wholesaler, or even from Chewy wholesaler. But a lot of the vets like the idea of a pharmacist being involved in this, but they want to have some additional control on it. And there's some economics for them, because if they're selling the economics solely as they're dispensing it, they take the full risk and the full reward. This one gives them some portion of the economics because they're taking some risk, but it's putting more safety into the pharmacist's hands. The vets have the complete choice if they want to dispense on their own or use this program.
So the veterinarians do receive compensation for medications that are dispensed through this process.
Let's clarify. The veterinarians are the ones who are receiving all of the compensation. They are then paying Chewy a fee for the product and the dispensing.
Doesn't this take away patient choice or owner choice on where a prescription is filled? And why wouldn't the veterinarians, if they didn't want to stock drugs in their location, just write a prescription for
Sure.
the patient to fill
The
it there?
veterinarians under the veterinary laws have to absolutely give the patient the choice. They can write a prescription. They can tell them this is an option for them or not, just like the MDs in this state can do it. And the veterinarians are allowed to. It's not any different than MD dispensing in that sense, where you can't require the patient to do it. It is simply an option for the patient. And I'm using patient to mean the pet owner and the animal, but yes.
If the interpretation of the law is what you're asking us to maybe adjust, how would it be different for humans? You said that this definitely wouldn't be legal for humans.
Sure.
Like, what's the difference?
The difference for humans is the Stark laws that prohibit the physicians from receiving any economics from a referral that they're involved with at all, to be able to do it, and the anti-kickback laws. And that would prohibit about 93% of all the prescriptions that are done for humans because of the insurance and the government pay to be able to do it. The medical statutes also have some prohibitions that do not exist in the veterinary statutes. And that would be for MDs and DOs and DDSs.
And I find this is already regularly done I have 3 different vets that are on my pets setup. And I already get emails from them indicating to use like an outside source to be able to do this. That's not Chewy. So it's already being done through vets. They would just have another opportunity for something that's local too. And one of the things I like about it is if you think about them holding the drugs at the vet clinics, you have to worry about the outdates and all of those things of them not being able to turn over their medicines, whereas this would be a lot safer in that kind of respect and a lot less wasteful. I see on that side of things.
So I just remember, this is my 3rd meeting. I remember a case recently with a physician that came in front of the board and wanting to do something very similar where there was a compensation or agreement. And there was another rule that was cited for a deviation request, and I can't remember what that was.
Sure, if I can remember, I that was not my client, but I was in the audience for it. It was a 340B one, and I believe it had to do with either kidney or liver functions that are there. But they wanted to actually open a pharmacy, and Arizona law prohibits a physician from having an ownership in a pharmacy that dispenses prescription that they write. This is not an ownership interest with it. This is simply a contractual one. It's candidly akin to some of the 340B contract to pharmacy relationships and issues from a legal perspective, but that analysis does not work on the 340B, but that was the one that you're referring to, Mr. Anderson.
How is the pharmacy supposed to differentiate their inventory from this veterinarian-owned inventory?
Sure. In today's technology world, they have a virtual differentiation, just like we do with 340B drugs in the pharmacy, but they can track it virtually.
So even though there's not stark laws that apply to veterinarians, just for as a pharmacist, the veterinarian getting all of most of the dollar amount for a dispensing of a prescription where they do virtually no work, doesn't feel very good. But I don't know, like legally, if I have any legs to stand on when it just feels wrong.
Well, and to be fair, and you know this from your business opportunities, as does everybody, most of the money that comes in just simply pays the cost of the drug. And then the question is, what level of cost for dispensing, which is what Chewy would receive, the veterinarian is taking the risk on payment here. If the payer does not pay, the patient does not pay, they're on the risk for that, and that's a real financial risk.
Yeah, I mean, for brand name drugs for sure, like Apoquel or whatever. But if we're talking generics, the reimbursements are a lot higher. And so if the pharmacy is getting $2.95 or whatever, and the veterinarian's getting $50, it just.
Well, and again, because the veterinarians have the choice, they can simply dispense this themselves under the state law, and this board has no jurisdiction. I have been fairly outspoken about it and have done in a public comment. I would love to have this board have jurisdiction on all dispensing of prescription drugs, doctors and vets as well. And then we can talk about some more things, but the law does allow the vets to do that. I'd like to have the pharmacists more involved, and this is a way to do so.
Madam Chair, if I may, I mean, there's two disciplines involved here, the veterinarians and the pharmacy. And I don't know if you've vetted this concept with the veterinary board.
I have not personally vetted this concept with the veterinary board, but as was pointed out and as I stated, this is going on now in lots of different ways, and there's nothing that prohibits a vet from owning the drug and being able to do this one. If the veterinary board, and I said it's been going on, and I said there's at least 10 states that have blessed this legally at this point.
I've reached out to some of the states that your client is licensed in, and they indicated, first of all, they had no idea that this was happening. Second of all, they said it would not be allowed in their state.
So to be fair, you and I had a conversation about this earlier, so with it, and I believe you identified 2 states that were not of the 10 that I listed here with it. And again, I'm not certain that those statements are accurate. I'm certain that what you're repeating is accurate. I'm not sure that the position on it, it's sort of a gut one. Boy, why do we have to share any money with the vets? But legally, I believe it works. And I said the only thing that was identified as a concern here is this 32-1983C with it, and I don't believe that's the barrier that's here. But if it is, I'm asking for the variance on it.
So real quick, to make sure I understand. So it's as if the veterinarians have already purchased the drugs, Chewy's a holding facility, and then they will just be dispensing them as a pharmacy would, but the vets own the drugs. So that's where their money is reimbursement for them already owning the drugs.
Correct. And again, if it helps you in concept, the contract pharmacy does that.
And the pharmacy retains all of the liability for the dispensing.
The pharmacy retains all of the prescription liability for it. The decision of prescribing the drug is obviously the veterinarians. And if there's a mistake in the prescribing and there's an interaction, there's a problem with the animal, I presume both that the vet will be sued as well.
Madam Chair, if I may, whose label is going on the bottle?
The pharmacy. The pharmacy is the one who's dispensing it. It will say Chewy Pharmacy.
So the vet is like another wholesaler, essentially.
They're not a wholesaler, but they literally own the drug, and they're being in with it, and they are contracting with the pharmacy to do the dispensing. Correct.
It's almost like
Like a
they're
virtual wholesaler?
like a virtual pharmacy.
Wholesaler seems like
I don't
virtual
know.
wholesaler.
Like storage, they're storing the medication in the pharmacy. Instead
I
of
don't
their
think they even
office.
touch the medication.
They never get it.
purchase
It's on paper. It's all on paper.
It's just on paper.
No, if they physically had it, the law doesn't allow them to give the drugs back to the pharmacy with it right now. That would be wholesaling.
Correct.
And the benefit for Chewy is that it is going to encourage more vets to use Chewy because vets get paid for drug dispensing.
I mean, Chewy is a pharmacy. Chewy is dispensing more prescriptions. It would have more volume. Presumably, it would have more purchasing power for it. And they are being paid a fee for their dispensing.
They're also a wholesaler, correct?
Right. They're also, there's Chewy Wholesale, which holds a wholesale license in Arizona, and there's Chewy Retail, which holds a retail.
So the
license.
veterinarian would be purchasing the drugs from Chewy Wholesale, and then the
In
Chewy
this-
Wholesale would be transferring the drugs to Chewy Pharmacy that would be dispensing them on behalf of the prescriber pursuant to the patient's specific prescription directly to the patient.
That is correct.
And they can purchase from Chewy Wholesale and not have it filled at the pharmacy if the
Yes.
patient chooses not to.
They can purchase from Chewy Wholesale and put it in their office stock. They can administer it. They can dispense it themselves. That's the doctor's choice, the veterinarian's choice.
I'm in favor of it if we're able to do it.
I mean, filling somebody else's inventory, and then this is a closed system, so it doesn't apply, but we'd be opening up a door, like adulteration issues, misbranding issues, whatever. I don't know what this category would be. I'd have to research some more, but it's filling somebody else's inventory.
It's just virtual.
Everything's on paper.
And again, the purpose of the law 32-1983C was to make sure you don't have counterfeit drugs and authenticity. And I said, this one, you do not have that issue with. That's not what this fits with. It's coming from a licensed Arizona wholesaler to a licensed Arizona pharmacy.
Madam Chair, may I ask a question of Mr. Morris? Mr. Morris, so Cam had mentioned adulteration and misbranding and the risk of that with the veterinarian owning the drug and Chewy Pharmacy dispensing it. If something like that were to happen, who would you believe to be liable?
Oh, I think the pharmacy would. The pharmacy possesses the drug. They would have the responsibility for storing it and making sure it's not adulterated in any way. I mean, in all candor, there's an awful lot of banks that own drugs sitting in pharmacies because of the credit and anything else that works with it. So to make that happen, but in this case, the pharmacy is very comfortable because they won't take drugs from the veterinarian. Only in this virtual model will they do it where they can be assured of the authenticity.
Well, I get that argument, but it's not the banks. You're borrowing money from the banks yourself, taking a loan, right, and then paying. So you're actually owning it, not the bank.
I mean, we'll look at it, but there are different ones. And then there are consignment sales into a lot of pharmacies also where the drug is literally owned by the wholesaler sitting in the pharmacy.
It feels a little bit like there's an interest from the vet, but in reality, the vet can dispense it themselves. So that feels like a conflict of interest in a way too. So I don't see it as being an issue. I think it might be more safe than the vet dispensing.
I think it'd be more safe as well, but it's going to actually increase time to patient care, right? So if you bring your dog in with an ear infection, the vet doesn't have a bottle of eardrops to give you like currently you would have happen at a veterinarian's office. You have to wait for that prescription to be sent and then filled and processed and shipped or whatever, because I would
Well-
imagine Chewy is not like a walk-in kind of pharmacy.
I don't think you would use it for acute care necessarily. It'd be more like things you take on just like a mail order pharmacy.
But they would have choice too.
Yeah,
Like
and
they said that they
patient
still have
doesn't have
choice. So
to.
if the patient can't wait,
Yeah.
they could take it someplace else.
That's correct.
I think if we're going to look at it from a safety perspective, and I agree, pharmacists are experts in the drug realm. Then holistically, we have to look at the dispensing authority of a veterinarian if it's not a safe practice.
And
That's
the
not in
best-
our purview, but it's in, obviously that needs to be addressed if that's going to be the discussion.
The best analogy I can use for this, because I was thinking about this, is if you're a medical doctor, according to the medical board, you can do any function you want in medicine. You can be a surgeon, you can be a general practitioner. None of us want to go to a general practitioner and ask him to do neurosurgery, but they're technically allowed to with it. Veterinarians are technically allowed to dispense, and in fact, they do. I'd rather have pharmacists involved.
No, absolutely. And if we discuss this, continue to discuss the safety of who can dispense better, then the real problem is, should veterinarians be dispensing at all?
What about the overlap in authority for inspecting? Since the pharmacy board doesn't have the authority to inspect the drugs stored at veterinarians.
They won't.
So how does that interaction and what other downside does that cause for the inspections in the Board of Pharmacy?
So we do get access in this model. I mean, we don't go in and inspect veterinary offices to make sure that they're following labeling laws and doing DUR and checking for outdates and all of that kind of stuff. But this would be dispensed in a pharmacy in Arizona that holds a license in Arizona that we would be inspecting. Is that
And
true?
in fact, have inspected.
I believe that's a good model for safety and improve the system. So I can make motion to approve the request. Is it for 1 year deviation, 2 years? I don't know.
Well, again, it's a question, if you interpret 1983 as allowing this, it's no approval needed. I just want to make sure everybody's okay with it. If we think it needs a deviation, then they'd request it for 2 years, and then we can come back and we can re-examine it. And I'm okay for you to approve it for 2 years on that, and we can look at it and deal with it. And if we can pull the dispensing authority from the vets during that time, that'd be great.
Yeah. I'm okay with deviation. I'm not sure about it. So my motion for deviation for approve 1 year.
Can we seek legal advice?
It wouldn't be a meeting without at least one executive session. I'll second that motion. All those in favor for legal advice? Aye. Welcome back, everyone. Additional questions after closed session?
I have like a logistics question. So if a animal patient had a prescription sent from their veterinarian that the drugs were owned by the veterinarian but stocked at a pharmacy. I mean, we're all pharmacists. We know how much drugs cost. And we've also probably, most of us, gotten prescriptions filled at the veterinarian's office and know that veterinarians upcharge quite a bit. So if the prescription is, say, for gabapentin capsules, and the veterinarian wants to charge $60 for 30 capsules, but if a patient had a handwritten prescription and walked into that same exact pharmacy and that pharmacy is going to charge $10, how does that work? Or like when a patient would call up a pharmacy and ask for a cash price on a medication and then come in and then that cash price is not honored.
Sure. The way this program works is that each veterinarian sets the price for their own drugs for it. So they set the retail price when it's going through that program. Chewy Pharmacy also has its own prices. Patient has the option of just having a prescription filled by Chewy at the price that the pharmacy would charge to everybody there is, or they can go through and buy it through the veterinarian selling it at the veterinarian's price, which could be lower or higher than Chewy's price. It's the veterinarian's drug. He sets the price.
Have you spoken to the vet board about this?
I have not spoken to the vet board about this. I don't believe Chewy has either, but I certainly have not.
So I had motion, I rescind my motion just to start. We didn't have second.
Additional questions, discussions, thoughts?
I would be curious to see what the vet board would, how they would feel about this practice. I think I would want to hear that side of it first before we make a decision.
So if I could, I mean, obviously the vet board can do whatever they want and their jurisdiction is over vets. This is over a pharmacy to be able to, which is who you guys have the jurisdiction over and over the wholesaler. I don't think there's any issue with the wholesaler, but if there is, we can discuss that to make that happen. Chewy took the inspector's word and said, hey, we're going to stop because you've raised this as an issue. Chewy believes that their process is legal. They're in compliance with the law. I have come here and presented that, and I put it as an alternative. If for some reason you guys think this is a violation, we're asking for the deviation. Certainly the board doesn't have to grant the deviation. It would be Chewy's choice then. If they think they're still in compliance, they may start this again. And I don't mean that badly, but I think 1983 allows for the delivery at an inspected site. So we can go back and I can tell them to go talk to the vet board or those issues, but I'm not sure what the vet board says about the vets make a difference here to the pharmacy board legally.
I think we ought to table this until we can gather more information.
And respectfully, I'm perfectly fine with that, and the board has that authority. Chewy raised this position in response to the March 2023 inspection and as identified for the board. So it's been sitting here with the board for almost a year.
I don't know that I'm actually against this. I get concerned on opening it up to all. But this particular situation, I felt pretty comfortable with. I also don't know if you'd be able to put it into practice if the vet board is not in favor of it.
Well, I think if the vet board has a problem, they absolutely will do it, and you won't have the vets doing this in any way, shape, or form. But I guess my advice would be, if that's the concern, I would approve this as a deviation because that's only specific to this particular entity and these ones. It doesn't approve it for anybody else. They would have to come back in at that point and ask for any other requests. And if something comes up in the interim, you guys can deal with it in that manner.
But then my concern is this, if we were to approve this as a deviation, then when the deviation request expires, then what's the next step?
That's 2 years, theoretically 2 years from now. You can approve for any length of time that you want. If you want them to come back in 6 months, we can do that. What I have tried to do with the deviations and the variances over the years is use those as experiments. And if they're successful and positive, then we should change the rules and make it available for everybody. That's how so many of your rule changes have happened, is deviations have come in. We've done them as variances. I mean, as silly as this sounds, I had to do a variance with you guys years ago so the pharmacists no longer had to write their handwritten initials on the label to show that they verified it. We were allowed to do it in the computer. I had to get that renewed 3 times before we finally changed the rule on it to make it tracked in the records. But my view is that the deviation should be used. Let's look at them. If they make sense, then change the rules.
I actually think I'm in favor of the deviation. It is only for them. I would like to get more information, but I also think that I would be in favor of the deviation.
I'd like to make a motion that we table this till the next meeting and ask staff to gather more information, specifically on the legality of it under the state law to confirm that, what the vet board has to say about it, and what other states are doing.
Just a thought though, getting additional information from the vet board, shouldn't that be their responsibility instead of the board staff's responsibility?
You're right. I'll take that off my motion.
So we have 2 very different thoughts on the floor.
Are
Was-
we able to?
But Madam Chair, I think we have a motion on that.
We have a motion. Do we have a second?
I would second if he, okay, so then I would second that motion.
So table to the April meeting with the intent of Dr. Gandhi and staff bringing back additional information.
No, Chewy staff will follow up with the vet board.
What other states?
Yes.
Do you have intention to go to the vet board and make sure that this is?
If that's the instruction that comes from this board, I will pass it back to my client. They'll make the decision.
Can we approve the variance and ask them to get information from the vet, provide opinion from the vet board?
But the meeting is gonna be, our next meeting is in April.
I'm not asking
So-
them for them to bring it back to a meeting. They can bring it to board staff.
I'm not clear on that.
Can we approve the variance for 2 years? And before it's put back into practice, that they provide the vet's board's opinion to the board staff?
So approve the variance. Approve the variance contingent upon receipt of agreement by the vet board?
At least an opinion by the vet board.
I don't know that I like that, just because I don't know, I mean, I do think it's a compelling thought to make sure that there's no concerns that they have. However, we make the decision for pharmacy practice, not the veterinary board. So what if we disagree with their opinion?
Then I just make a motion to approve the variance.
There's already a motion and a second on the table.
Oh.
No, we did not vote
Make a
yet.
motion, we table the next meeting, that we ask them, to talk to the board, to the vet board, and that we ask staff to check on the legality and what other states are doing on this.
Yep.
So I have a motion and a second. Any further discussion? Dr. Gandhi, let's do roll call, just for fun.
Mr. Thorwald,
Aye.
Ms. Nair,
Nay.
Ms. Davis,
You're like, skip.
Nay.
Ms. Walmsley,
Nay.
Ms. Lehan,
Nay.
Mr. Dang,
Aye.
Mr. Al-Nassif,
Aye.
and Mr. Anderson.
Aye.
Motion is a tie, so it fails.
I'll make a motion to approve the variance for 2 years with an update at 6 months. Or every 6 months, how about that? Then we have it, no. If we're concerned about the practice, I would just be fine with the variance for 2 years. I was just trying to be. Okay, my motion's a variance for 2 years approval.
A deviation.
Deviation.
I'll
No
second.
reporting.
Right.
Could we do a deviation and more research? Like kind of a combination of the two
Mm.
motions?
But they.
Then you're gonna try to put the toothpaste back in the tube.
Honestly,
Trying
like,
to figure out the legal term for that.
as they said, they've been waiting for 1 year, right? If like getting 2-3 more months just to gather more information, I don't see gonna cause any harm to anyone, right? And they paused this process after the last inspection. So I really see like table this to the next meeting and we get our board staff to gather more information and seek vet board opinion, just as an opinion to see. And then we
I'm not
can
sure
make
if
decision.
more information would be so compelling.
I mean, but who knows, maybe they don't need the deviation, maybe the rules allow them, who knows? You know what I mean? Like if we get more time to dig on it, or you know what I mean, gather more information. So I believe like
I
2-3
don't-
more
does-
months.
Does our approving this make it that they wouldn't do more? Gather more information? I think that they might just on their own.
I guess the advantage of waiting another meeting is we might have another board member, which would mean we wouldn't have a tie. I don't know.
My opinion is that it seems that legally we have the authority to grant this deviation. I don't much like this practice. I don't necessarily think veterinarians should profit for pharmacists dispensing of drugs. I don't much like the idea of it, but from a legal perspective, it seems like it is legal and we have the authority to grant a deviation.
From our statutes and rules.
From
We
our
have- But
statutes,
we
not
have a
ours.
slight overlap with the veterinarian, so we can't deviate from theirs.
Yeah, but we're
We
not
don't
making
know.
any rules
But
for
if, but
the
if the
veterinarian.
veterinarians are breaking their own law by entering into this contractual agreement, then that is on their board to deal with it, not on our board to deal with it. I kind of agree with where you're going with this. And at least pharmacy is a part of the equation, right? So we have more jurisdiction than we have today over those products. So from that perspective, we have more oversight than exists.
Just I have a question. So why vet purchase those, why you just, you as the pharmacy there, just you purchase it, you dispense medication just like any other pharmacy. And at the end, like every 3 months, you reach out to vet, say, you know what, we got that amount of prescription from you. You know what I mean? And we give you that much money, you know what I mean? I mean.
You're asking why they're doing the
Yeah,
program?
so what's the difference? I mean, like, why you need the vet to have virtual inventory in the pharmacy versus the pharmacy own the medication, their own medication, they dispense it, and then they see how many prescription they give from that vet office, and then share the profit. That, you don't need deviation, you don't need anything, right?
Well, this particular model, I said, they didn't create this model. This is the model that VetSource created at least 9 years ago, that was vetted by the Nevada board. They went to litigation. Nevada actually passed laws on it. And I said 9 other states have passed it. So they're trying to follow the model that is already in use in legal. And frankly, numerous vets, the majority of vets, and just to be clear, this isn't exclusive to the vets. When I say that, the vets can work with the Chewy model. They can also work with the VetSource model. They can work with 4 other companies. They can sell the drugs themselves. This is one option for them, is all it is. But we're trying to get as much to the pharmacists as we can from Chewy on this.
Yeah, but what's the benefits for animals or patients with this module? First, that just Chewy Pharmacy on all stock, vets having nothing to do with it. So we are compliant. We don't need to.
I think Chewy would love that if they could, but the vets aren't willing to do that.
Chewy would reach out to the vet's office, says, you know what, like we can have agreement or something, and that much money I can give you because of your business.
Well, I think
mean,
that would be a
yeah.
fee split, which would be a violation of the Arizona pharmacy statutes for the pharmacy to do that. To just give them a kickback would not be appropriate. That's not okay.
Yeah, I'm not a lawyer, but I'm trying to understand, but why the kickback here and not there? I mean, that's what I'm trying to
Because
understand.
the vets truly own the drug and they are fully at risk if the patient doesn't pay. There's a legitimate, I mean, it's the ownership of a business that you're at risk for it. And this model, I said, has been vetted in a number of states and meets that.
So there is a kickbacks, not only.
There's not a kickback.
Yeah.
There is a profit margin that the doctors make.
So in other words, when the person gets the medication from the vet hands it to them and says, now pay. In other words, they don't ask them for the money up front before they gave them the product. That's seems strange to me, but I think the risk there is somewhere between minimal and zero.
Chewy, I said, is not dealing with novel ground, other than they're in front of the board, putting this in front of you so everyone can see it and going what's on. This is going on today with lots of different folks that are there. And I said a number of boards have had this in their hands for almost a decade.
And what's about control medications? If any
Controls aren't part of this.
Is not part of this. Okay.
No controls.
And does VetSource hold a license? I don't want to get too far off the topic, but do they hold a license in Arizona? I think they do, don't they?
Let me check.
Which means that they could be dispensing drugs into Arizona using this very process.
How would this work if the veterinarian is, say, located in Minnesota or something, and then they have this model arrangement with Chewy where the dispensing pharmacy is located in Arizona? Like, what if it violates somehow Minnesota law?
if it violated Minnesota pharmacy law, then Chewy would have a problem with it and couldn't do that into Minnesota. If it somehow violated Minnesota veterinary law, that would be the veterinarian's issue.
VetSource is licensed here, but doing this practice in another jurisdiction, they would never know. We caught it basically because we did an inspection. Pharmacy boards across the country are not coming to Arizona to do an inspection. So other states will not know whether they're in violation of their law.
So Chewy would have to do like a state by state analysis.
In essence, right now, I think, Roger, you indicated 1,300 locations. There's 1,300 partnerships across the country. Is that,
Number sound right to you, 1,300?
is that correct?
No, that's an old number. You're talking about participants?
Yes,
2,000.
about 2,000.
2,000, so it's gone up considerably from 1,300. And that's across the country.
Correct, that's across the country.
So we don't know if it's legal or not in those states because we weren't notified. So I'm assuming they didn't notify the other states either.
Just to be clear, the fact that the board isn't notified about unique arrangements doesn't make something illegal.
These are unique because you ship to, wholesalers are supposed to ship to the address on whoever ordered it per se, right?
Well-
So it was kind of sort of in violation. It would have been nice if they checked with us if that was okay or not.
And again, to be fair, that's an interpretation of a law similar to 1983C. And I said specifically, I know California, Texas, and Wisconsin have specifically looked at this 1983C equivalent and said, as long as you're shipping to a licensed address, it doesn't have to be the same as the purchaser's address.
And I believe there is something like sold to and shipped to, right? You can differentiate.
Correct.
Yeah, it can be
And-
like
and-
sold to
and-
the vet, but shipped to the.
And we get into a lot of that. There's an awful lot of pharmacies that the payer in the pharmacy is different than the ship to because of chains, warehouses, other locations, same thing with hospitals.
Yeah, we use this with 340B, like. shipped
And
to
that 340B is a
sold
good
to.
example. It's how narrow you get on a definition here.
So wrapping up discussion, do we have a motion or not?
I did.
Huh?
We
We did.
We did.
Motion to those back.
We had a motion to approve.
So Ms. Wayhand did.
Okay.
Ms. Snare moved, Cedar seconded to approve the deviation for Chewy.
I'm glad you're taking notes, Jean, because I can't keep track. All right. Any other discussion or let's do a roll call on the vote
I
unless
have a
there's.
quick question,
Okay, go ahead.
madam. I have a quick question. How did you come up with the 2 years?
That's generally what we do for deviation or waivers.
So my quick opinion on this is I'm not opposing to the approval of the deviation request, but because of our decision may overlap with the veterinarian practice, that's why I suggest that we just, since they meet every month, why don't we just wait another 2 months and come up with a final decision? And that decision will stay forever. Let's say we allow
That's
2
on them
years,
To do.
but then
Or
let's say
they're
when,
Deciding, the vet board is deciding if it's the safe practice. That doesn't have bearing on what we decide today.
And we don't
And
want it
it's on
to
Chewy
be
to-
forever.
to
We
know.
want it to be only for this model because otherwise could put a potential snowball effect that could be problematic. But within the same company, I can see a deviation being appropriate, but we wouldn't want to say out loud that this is appropriate for everybody.
But if it's gonna get out at all, anything always gets out. So somebody else is gonna come in and say.
Then we can decide case by case.
Case by case based on the merits of the request.
I think one point that has been stressed is what makes this unique is, Chewy's closed door and self-contained versus a pharmacy that is not. I think that was one of the driving factors that I've heard that should be made on the record.
But if we grant the variance, somebody else is gonna ask for it. That's not closed chain.
Mhm.
And then we have a precedent that we have to deal with.
But that, what I'm saying is, what I'm hearing is one of the factors that the board did consider if you decide to grant this deviation is the nature of Chewy.
I mean, we have a motion and second now, right?
Yeah.
I mean,
Any further discussion? Dr. Gandhi, please take a roll call.
Mr. Thorwald,
Nay.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
nay.
Mr. Al Nassif,
nay.
and Mr. Anderson.
Nay.
Well, we are in the same place that we were before.
I mean, like really 2 months will not gonna cause any harm.
That's
You
my
know, like,
point.
I mean, they've been waiting for 1 year.
That's
And they paused
exactly.
it. And just for future, we will have a better answer,
Right.
right? I believe like we meeting in April and they meet every month,
Mhm.
right? And then maybe they have different point of view, like,
I just think it's on them to, if they want to appease the pharmacy board and the vet board, then that's on them to seek those things out. That's
But-
not on us to seek that out. And I don't know. I just think that's two separate issues.
But Kristen, I understand that it's on them, but then veterinary board has its own laws. If veterinary board comes back and say, no, that's illegal on their side, that means they're gonna have to come back to our board and we're gonna have to
No.
revoke the deviation request.
No, they won't be
just
able to
cannot do
do
it.
it. They
But
have to
from,
be in compliance.
but from the legal standpoint, today in the meeting minutes, we allow them to do whatever they wanted
Right,
to do.
we're allowing it, but the vet board has to allow it as well.
That's true.
So how about
They're
this?
both
Rather,
independent decisions.
how about this? In between solution. Let's table it for the next meeting, allow Dr. Gandhi and Mr. Morris and staff to have some discussions around what other information might be necessary. Hopefully to bring it back for the April meeting. There's no guarantee if there's the need to meet with the veterinary board that that's going to be done by that time. So I don't want to put a time frame on it. But maybe let's just keep it open-ended that we will table it for further investigation. Then there's no decision on the record. There's nothing negative. There's no, we're not beholden to any certain amount of information. But allow the staff to continue to do additional diligence and bring it back to us as soon as possible.
Isn't that the motion that failed?
No, there were some specific requests.
I just don't know that, I mean, I'm fine with it if that's what we go. I just don't know that any outside information is gonna change my opinion, but I'm open to it. No, no.
Madam Chair.
There are four people on both sides of this that I feel like feel very differently, and I don't know what would be an other in between that we're gonna get you. Yes, Mr.
There's
Madam
also
Chair
a
has-
slight possibility that between now and April, you may have your vacancy filled, so there could be a tie-breaking vote at the next meeting.
Yeah, that was my other thought.
Okay.
Madam Chair, is that a motion?
Madam Chair doesn't need a motion to table its subject matter.
If it's a motion to table the matter, I second it.
So moved. Do I have a second?
My second.
Sure. All those in favor?
Aye.
Thank you for the robust discussion. I will talk with the
Thanks.
client and I look forward to seeing you again.
Thank you,
Thanks.
Mr. Morris. Thank you, Mr. Zelinski. All right. 32G. I bet you didn't think it was going to take that long after our last couple of discussions. Please join us at the table. Kenneth, if you could pronounce your last name for me, since I know I butchered it. Okwebi. Welcome. Please introduce yourself for the record, and then I'll have Ms. Torres start with the summary.
My name is Kenneth Okwegwe.
If you could please give us a summary.
Kenneth Okwebwe applied to reinstate his Arizona pharmacist license on January 7, 2022. The application was closed due to not providing proof of current work experience as a pharmacist and taking and passing the MPJE. Mr. Okwebwe disclosed a voluntary surrender of his California license. On June 26, 2020, Mr. Okwebwe agreed to a stipulated surrender of his license and order issued by the California Board. On July 27, 2020, the California Board issued the decision and order implementing the surrender of his license and those of the pharmacies. The discipline was a result of 84 causes caused or issued to Mr. Okwebwe, Drake Pharmacy, and Rockforth Pharmacy. The stipulated surrender of license and order does not allow Mr. Okwebwe to apply, reapply, or petition for any licensure or resignation of the California Board for 3 years from the effective date of the decision and order. He is also required to pay the California Board its cost of investigations and enforcements for $30,000 prior to the issuance of a new license. On January 2nd, 2024, Mr. Okwebwe reached out to the Arizona Board requesting the board's permission to reinstate his Arizona pharmacist license.
Thank you. Mr. Quigley, would you like to make a statement?
My name is Kenneth Okwegbe. I'm a foreign trained pharmacist. When I first came, I started my pharmacy practice in Arizona, in CVS with Indian School Road. I worked as a pharmacist here for about 10 months thereabout before I moved to California, where I continued my pharmacy practice. In California, I also continued with CVS Pharmacy as a staff pharmacist. I worked with CVS Pharmacy for about 5 years. And along the line, I opened my own pharmacy. After about less than a year, I opened another pharmacy in a different location. The reason being because my patient grew rapidly. Why did they grow that rapidly? Most of the patients that went with me to CVS Pharmacy, to Drake Pharmacy, came from CVS Pharmacy because I have a one-on-one rapport with my patients. I treat them nicely. And when I left CVS Pharmacy, they inquired, about my whereabouts, and they were told I left. And most of them followed me. They said, wherever I go, they will go. And my pharmacy grew rapidly. When I looked at the demography of my patients we had and where they were coming from, though the doctor's office was very close to the pharmacy, their doctor's office was very close to the pharmacy, we found that some of them were coming from a certain area in California. We now thought it wise to open another pharmacy in that location to make it easier for the patients. This happened, these two pharmacies were open in a space of 1 year. And I have, by God's grace, I treat everybody well. I relate well with them. So that made both pharmacies to grow. When I was going to open, Drake Pharmacy was opened in 2012. When I was going to open Rockford Pharmacy, he was a temporary pharmacist, but he decided to come on full time with us, Mr. Leland Chu. At that time, he passed now. At that time, he was about 78 years old, very hardworking man. And we had technicians that was actually working there, and I was in different pharmacy. We grew so fast that, would I say it got into my head? I wasn't overseeing the day-to-day affairs of the pharmacy, which I deeply regretted. We had medications that were past 14 days that were not returned to stock, which of course I deeply regretted. When the Board of Pharmacy came for inspection, I was in Rockford Pharmacy, and my attention was called that when they came the first day, Mr. Leland Chu was not able to answer all their questions. And I offered to come over to Drake Pharmacy to help with their investigation. And when I arrived, of course, the inspector, the way the pharmacy was actually shaped, we have, a high ceiling with a little area that was secured. That was where the pharmacy was situated. This high ceiling area was naturally, secured to put the pharmacy because of break-ins. This part of the pharmacy was reinforced on the top, so we can put a gate to reinforce the pharmacy. We didn't have enough room in the pharmacy because I did not know that the pharmacy was going to grow that quickly. I had in mind of opening a little pharmacy to work, but the pharmacy grew and it outgrew that space. We also have, at that time, one pharmacist, Leland Chu, and about 3 technicians. No, at that time, 2 technicians. Before it was 3, we lost 1 person. And normally what we do is that since we didn't have enough room in the pharmacy to process prescriptions, we also had a delivery driver at that time who would take the medications. There's an upper room, which we used as a break room. We would take the medications up there, combine that's bags, for example, patient that has more than 1 prescription, put them together in 1 prescription to be delivered to the patients. It was at that time that we lost 1 technician and we forgot, and we left those medications upstairs. Invariably, we forgot about them until the inspector showed up for inspection. And of course, she had access to everywhere in the building. When she went up there, she found those medications and asked us what they were doing there. Before I came to the pharmacy, the technicians already told the inspector that they were meant for delivery. And truth, the medications were filled, those were left upstairs more than 30 days ago. And they weren't supposed to be there. They were meant for patients. What we were doing at that time, I say we because I was the PIC. I cannot exonerate myself from what happened then. I bear full responsibility of our actions there. What we're doing then was when a patient comes to pick up a prescription and we cannot find the label or cannot find a prescription, we simply go to the computer and reprint the label and refill again that same prescription and give it to the patient. And that took time, but we could not find it anywhere. It's not on our shelf. We did not remember that those medications were up there. Though in the break room, nobody used them. Nobody goes up there to take breaks.
Can I jump in real quick?
Yes, ma'am.
You said those are for delivery to patients?
Yes, ma'am.
How could they be forgotten? Weren't the patients expecting them to be delivered?
Yes, ma'am.
So
We lost an employee at that time, so we couldn't go back to them. Like I said, patients will come. Where is my medication? We check our shelves, it's not there. They did not remember that there were about 2 or 3 boxes left upstairs. So what they will do is they will reprint, label, and refill again that same medication that patients will come looking for.
I'm sorry, I have a question now. Here, sir. So if those medications set up for delivery, at least the patient should be aware of that. So when patients call a pharmacy or come to pharmacy, we say, hey, I didn't receive my delivery meds. So your staff should have known to go at the delivery storage area, whatever it was. But I mean, I don't really get it. I mean, like, at least if your staff not aware of, your patient should be aware of.
Madam Chairman, I'm sorry. It seems that we're relitigating the facts that led up to the revocation in California. And I don't know if that's appropriate. That has been litigated. He was revoked, has been ordered not to reapply in the future. So I don't know if it is valuable use of the board's time to relitigate the underlying facts.
I was just going to go there, Ms.
I
Galvin.
just feel like some clarity and understanding how we got here. That's
Well,
all.
we
I
got here.
read
There are
it. I just didn't
84
understand
causes.
it.
There were 84 causes for discipline.
Yeah.
And real quick, for the record, I do want to make mention that I work for CVS, but I'm not familiar with you or your circumstances. So I can sit this out or I can be part of that. That'll be up to you.
Yeah, I worked for CVS. That was when I first started. And I believe it's Indian. I'm not too used to Phoenix. Then I was new. I believe it was Indian School Road, the 24-hour CVS. I was a night pharmacist.
Do you have any problem with her staying, even though she works there currently?
No.
Okay, that's what I wanted to make sure you were comfortable.
No,
with.
Yeah.
I'm fine.
We just
I
want to
can be
make sure. that-
impartial.
Okay, that's
Yes.
fine.
Have you ever been audited or investigated by an insurance company?
No, ma'am.
You were ordered to pay $30,000 to the California board. Has that been paid?
Can I say something, please? If you, no, it hasn't been paid yet.
It hasn't, you haven't been, have you paid
Because-
any of it?
No,
Okay, thank you.
Are you
Uh,
also licensed in any other state?
no, sir.
So just Arizona
And
and
California,
California?
yes.
What have you been doing since your license has been revoked?
I've been working as a factory worker since about a year or two thereabout.
Okay. Have you been keeping up on your continuing education?
Yes, ma'am.
I don't think we should relitigate all of these facts, obviously, but there seems to be a real lack of judgment in all of these facts that were presented by the California board, and there doesn't seem to be there's any accountability. So that is my initial perspective on what's happening here.
Can I say something, please? I was never given the choice to appear before the board. I never appeared before the board. They never asked me to tell them my story. I was never given the option. During COVID, all I had was a mediation judge mediating between me and the board. They offered me only two options: stipulated surrender or revocation, which I struggled with both of them. Yes, I agree I made a lot of mistakes. I agree. That was why I did not pursue the reinstatement when I first inquired about it. I said, let me wait and serve the punishment 3 years that was meted for me. Yes, because I agree I made those mistakes, and it was not intentional for me to be said that I'm fraudulent. I'm not. I made mistakes. Yes, I agree. But those medications that were not returned to stock before the board inspector showed up, we returned everything. And I have proof of return. And we have proof from my training book. The board inspector said, I put them on hold. Yes, I put them on hold. And why did I put them on hold? That is the right thing to do based on the training that how we're trained on how to handle those prescriptions. This is from the owners of the computer that trained us on how to use our software. It's all here. And I told them they were not picked up, but they've been reversed. They reversed them back to stock. They misunderstood me that, whether because of my accent, but they said I should not put them on hold. I said, ma'am, I told them that is the right thing to do, but they never believed me. If this is the book right here on how to process them.
I have a question for you. So if we were to decide to do something and give you your license in whatever form today, what do you intend to do with your license?
I intend to work for the chains to learn more about the process. I intend to work for the chains and get paid so that I can see my children through school. Although I've been working as a factory worker, it's not able to pay my children's school fees.
So you don't intend to open another pharmacy?
No. The board is free. It's very free to monitor me while I work. I'm very open to whatever thing you want to do. I just want to be able to pay my children's school fees. That's all.
I don't think I'm comfortable at this time. I don't want to base it solely on this, but I would like to see California settled completely and him regain his license through them and finish that matter before he comes to our board and asks to be reinstated. That's my opinion.
I have this from California State Board of Pharmacy. After the 3 years, I actually contacted an attorney to have my license reinstated. I submitted this, my attorney submitted this to them, and this came back that I should reapply, that matter was closed, that I should reapply for a new license. This came from them. The 3 years it gave me expired August 22nd of 2023, and they said I should apply for a new license, which I did already and is in process. They said I should apply for a new license. It's right here. I already applied. This came back from them.
I don't believe that's in the board's possession, and I'll remind the board, according to the documents, he did consent to the revocation of his license and to the permits of the pharmacies that he owned. It was, he voluntarily entered into that consent agreement and he was represented by an attorney at the time.
I just don't have confidence at this time. I don't feel like that's been demonstrated yet. Maybe at a later time, but just not right now. And I'm willing to make that my motion to deny this request.
And that is based upon the previous disciplinary action in the
Yes.
state of California.
Yes.
Second.
Any further discussion or additional questions? He's eligible to apply for a new license, correct? In California at this point,
Yes, 3 years has passed and I've applied already.
but they haven't issued your license yet.
They said, they're not using process. They've not issued it yet.
Yeah, in California it takes a really long
I
time.
think there was a stipulation of also paying the civil penalty upon applying.
And that money I don't have. I do not have that money. Even if they approve my license in California, I don't have that money to pay.
So that's the only thing holding you back at this point from California.
I don't have, even at the point where we're supposed to go for litigation, the mediating judge said, even if you win this case, the board could say yes or no, or move, but you have to, at that time, I was already owing $80,000. And the mediating judge said, before we finish this case, you'll be owing well over $200,000. I don't have that money. And, initially, I don't have that money. I simply chose, okay, the license revocation or surrender. I don't have that money. Now, clearly, I made mistakes and I'm deeply sorry about those mistakes. And that will never, ever happen again. All I ask is just to be able to send my children to school. As it is, I cannot afford to send them to school because what I make as a factory worker is barely like $2,000 a month. I made mistakes. The 3 years they gave to me has passed. Even if they say your license is ready now, I don't have 30,000.
Madam Chair, I think our board has run into similar situations of that, and we've reconsidered our civil penalty. We've advised them to set up some sort of payment program with an outside entity. So we've worked with individuals that have come with a similar story or situation as this. I'm not sure if, Sir, I don't know if you've approached the California board with your concern about not being able to pay that dollar amount?
Well, they didn't give me the option to approach them like.
It's not up to them to approach you. It's your responsibility to approach them.
I don't know that California offers the same
Yeah, it's still,
situation. I don't know that.
it's something that he should try. Nonetheless.
Are we your home state for your first license? Sorry, right here.
Yes, ma'am.
Okay.
You made a motion and it was seconded. Let's do a roll call.
Absolutely. Mr. Thorwald?
I have mixed feelings on this. I'm gonna say nay.
Ms. Nair?
Aye.
Ms. Davis?
Aye.
Ms. Walmsley?
Nay.
Ms. Lehan?
Aye.
Mr. Dang?
Aye.
Mr. Al Nassif?
Nay.
Mr. Anderson?
Aye.
5-3, ayes have it.
Thank you for your time. We've voted to deny your request at this time.
Thank you.
Thank you for being here in person for us.
Thank you. Can I reapply at a later time?
Dr. Gandhi, can somebody from staff talk with him?
Certainly, we'll reach out. You have my contact information?
No, sir.
Okay, if you want to step over, I'll give that to you and we can have a
Okay.
discussion next week sometime.
Yes, sir.
Thank you, Dr. Gandhi. That takes us to, I believe, 35, election of officers. Is that correct? Or have we covered everything else?
You're correct, 35.
All right, so I will open it up for discussion. It's the time and place for us to discuss officers for this year.
Well, I'd like to really thank you two for all of the hard work that you've put in and everything that you've done this year. And you've, great in all of your learning experiences being newer on the board. And I'm open to other suggestions, but I also think that you both did a great job. And so if you wanted to stay in that position, I'd be in favor of that as well.
I would like to say the same thing. I think, hope you would stay in the same, we would keep you in the same position if you want to be.
I agree.
Ms. Wormsley, I have to say you have done a phenomenal job as the chairperson for this board over the past few years. So I'm in favor of having you continue serving the board as a chairperson. But I would like to nominate Mr. Anderson as the vice chair, so that he can get more acclimated to the board and perhaps he can serve the board as a chair down the road in the future.
Thank you, Dr. Dang. I would accept the nomination.
Ms. Walmsley, I will nominate you as president if you are willing to accept.
I would be happy to serve in any capacity. Do we have a motion for Ms. Davis to remain chair as well? Do we want to handle all three?
I'll make a motion for Ms. Davis to remain as vice chair.
Okay, let's handle the chair first.
But can we do it by acclamation for all three, all of them at once?
All three of them at once.
Everybody at once.
All right, for President, Ms. Walmsley, Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley.
Abstain.
At least it's not an A. Ms. Lehan,
Aye.
Mr. Dang. Aye. Mr. Al Nassif.
Aye.
and Mr. Anderson.
Aye.
So it's been a while since we've had two nominations. How do we want to handle that? Do we want to let them each say a little something before we
That would be customary.
deliberate? I think that's what we did the last time we had this situation. So
Yeah.
whichever of you would like to go first, go for it.
I greatly appreciate the nomination, Dr. Dang, and I've enjoyed my 3 meetings thus far. I just got my reappointment from Governor Hobbs this week, so I'm excited to fulfill that 4-year term. I think I've actively already started contributing to the board in some positive discussions. I think Ms. Walmsley would be a great mentor for me in a vice chair capacity. And I think my broad experiences in pharmacy practice, being a hospital pharmacist today, also having retail experience, extensive experience in clinical pharmacy services as well. I think I'd bring some additional value to the leadership team of the board, and would welcome the opportunity if so elected.
Thank you, Mr. Anderson. Ms. Davis?
Hey, everybody. I've enjoyed serving as vice president of the board at the board's pleasure. I'm happy to serve the patients of Arizona and board members, board staff any way that I can, and helping shape our decisions and be behind the scenes with Ms. Walmsley, kind of answering questions. I'm happy to continue to serve, but I'm also happy to continue as a member of the board. So, I'm not, set on one way or the other. So.
All right.
Who shall we take first, Madam Chair?
You're killing me.
Shall we do it like? All right,
I don't know. You want to do it alphabetically?
all right.
Okay, Mr. Anderson.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
I think I should abstain.
Ms. Walmsley.
Can I vote for both? Aye.
Ms. Lehan?
I would like to be in the same position to vote for both. I think it'll be nice to give them an opportunity too, so I.
Mr. Dang?
Aye.
Mr. Al Nassif?
Aye.
And Mr. Anderson?
Abstain.
Ayes have it. We could have a tie if we vote for. But the ayes.
Oh, let's do that. That'll be fun.
ayes do.
No, I think it'd be fun for Mr.
Yeah.
Anderson to have a chance to be in leadership and be in the pre-meetings and all of that fun stuff, get the behind the scenes action. So I'm happy to pass the gavel.
That's a good runner-up speech.
That is an
Mhm.
excellent runner-up state.
Yeah.
And yeah, can we create a new position? Is that on the table? Can we have a vice chair?
External affair and internal affair.
Secretary, treasurer, can we have some more positions?
We'll work on it. We'll work
Okay.
on it. But congratulations, Madam Chair, on your reappointment.
Thank
as
you. I
president.
appreciate, and I appreciate all the kind words. Looking forward to the next year. And honestly, just want to commend the new board members. We've had 3 new board members in the last year. And I think everybody has really contributed very quickly and we haven't missed a beat. So I appreciate everybody jumping in so quickly and contributing to the board. I
And
think
just
we're
to add-
very lucky.
Yeah, and just to add, we will have a new board member next meeting.
I know you mentioned that quietly.
We just have
me.
to do the onboarding here in the next couple of weeks and to hit the ground running.
Great.
So, Mr. Anderson, congratulations.
Congratulations.
on Your opportunity, and thank you again for your service to Neil.
Yes, it's been a very, very big pleasure to serve with her. Let's do is there any other agenda items anybody wants to add? Let's go back to that after, if there are any additional thoughts after another day of meeting. Anything for future agenda?
I think this meeting was pretty lengthy in the board book, and when you look at the agenda, I think you've done a fantastic job running this meeting. and
Thank you.
Keeping it going.
Madam Chair, I will say this for myself as a non-pharmacist. I would certainly like to be able to tour a pharmacy and other types of facilities to better understand and see equipment, see what's going on, and to be able to see what you all see. And so I don't know if that's possible to do, but I would like to make that request.
Thanks for that suggestion. I think we
I'll
can talk about
second
that with
that.
Seth.
We have that message, and we will try to figure out logistically how we can try to make that happen.
With quorum and all that good stuff, yeah.
Well, quorum and other
Yeah,
things that we have
gotcha.
to consider.
Anything else? Hearing none, let's do call to the public. Roger, do you have anything to add today? All right. Anybody else?
I just want to thank you for not adding to my list today.
We give you enough. Did we put up the message yet? Are we good? Okay. Are we sure that there's nobody in the public that wants to say anything? Okay. We don't have anybody. We will adjourn the meeting at 2:57.
Hey, thank you.